but it became a surprise from me. Other side mentioned it. So that is why 2 weeks
You want
after.
the short accommodation?
Yes, yes.
When do you want?
Immediate 2 weeks
Which
after.
year matter it is?
It is
2023. 2020 matter?
No, no,
2023. 23 matter. All right. 2 weeks after. I'll inform the other side.
Other side I will inform. I talked to him, but he said I will place high. That is why.
Next.
The Lordship's kind permission. Item number 147 of the weekly list, for the respondent. There's some urgency because since 2019, my promotions are held up. I'm requesting if it can be taken up in the supplementary list next week, subject to my Lord's.
Let us see. Let us see.
Item 10 of the supplemental list. Caveat has appeared. So I have to serve a copy, has to me. So let it come on next week, I'll serve a copy.
Who is the
Bhavani Shankar Das.
He is not here.
No, my lord, I have already talked with him.
You are talking to
Yes, sir.
He is appearing for registered cooperative society.
No, he is appearing for private opposite party. Caveat.
After 2 weeks.
1
week. 1 week we have difficulty. Next week already calendar is full.
Because this is fresh admission, I have to only serve a copy. That is why he has requested me.
All right, next week.
Let's see.
Item 5.
At the request of Caveators Council. You are for Caveator?
No, I have
petitioner.
Yes.
After 2 weeks. At the request of
1 week.
Council for the petitioner. Next.
Item 5. You nominate the petitioner. I took time to remove the defect, which cannot do on other councils is filed. Now I am going to effect. May I permitted to take from pen drive, then I can sort of the bulky of papers. So it is permissible. On pen drive, I will collect and accordingly I will remove the defects.
GSTI Mr. Padi on request is permitted to collect the pen drive papers and do the needful within 1 week.
Yes, sir. Item 26.
Call me after next.
Item 26.
You are the caveator in item number. You are not passing any order, na? You see that? Yes.
Item 26. For SBI, I need 2 weeks time for filing a count.
26.
Yes.
Item 25. My senior Mr. SK. Yes, yes.
Let it read, item 25.
Yeah. We are taking 26 now. 23. If you permit, we will treat it. Otherwise, we can intervene.
Sorry, madam.
26, 1 year is over now. You have not filed the counter. Only 2 weeks are permitted under your rules. 2 weeks at the request of counsel for the OP for filing counter, if any, filing which right to file one stands forfeited. And petition averments may be taken at face value.
25, my lord. Due to illness of senior Mr. SK, that will kindly be taken up 1 week.
But you are petitioner.
Yes, sir.
Have you interim order here? And the interim order?
Interim order of stay is here, my lord. Security proceeding. Last 1 year stay is there, and my lord, the high value, my lord, about 10 crores is outstanding. And the bank is not a position to proceed further.
1 week he's will put it when
Next week, any date, your lordship, my lord.
next week, perhaps Monday next. Monday after. All right. Not this Monday. Means after this Monday, another Monday comes. Call Monday after next.
About matter. Benefits are due from 1980.
Covered by judgment. Covered by judgment.
Apex Court, 4 judgments of Apex. This is a postal matter, my lord, except Odisha, in other parts of power.
Week after next.
Item 17, my lord.
17.
17, my lord. I may be permitted to withdraw.
You want to withdraw?
My lord.
We want some more people like this. 17. Have you filed the memo? You file a memo. Learned counsel for the petitioner seeks leave of the court to withdraw the petition. She has also filed a memo this day, which reads as Approval. SIC.
Item 18,
Ordered accordingly, the petition is disposed of as having been withdrawn. Copy of the order to go to be sent by speed post by the registry to the OPs.
I may be pardoned, Lordships. Item 18, my lord, I pray for an adjournment. My senior Mr. Acharya is not keeping well. So if Lordship may take it up any other day.
2019 matter.
My lord, last opportunity, he is not keeping well. That is why I'm praying for
All
him.
right, 2 weeks on health ground of the arguing counsel
Obliged.
appearing for the petitioner.
Yes, your Lordship.
Okay.
Grateful, Lords.
Supplementary list.
In the meanwhile, office defects to be removed. In the meanwhile, office defects to be addressed. Okay.
Supplementary list item 1, date appeal 8/1/2025. Yes, pronounced.
Appeal dismissed. We gave 1 day time to file a written submission. You have not filed. We do not keep the matters pending because we may forget. Therefore, we have written.
I have never undertaken to.
No, others. Others. And certain things were not disclosed to us also. Just we went through the entire file. We spent a lot of time on that.
Item 2, WPC 16806 of 2023.
Please, Lordship.
Yes.
In the case against the order of the Central Lawrence Central Tribunal Kotak, 20th January 2020.
When will you get a complete repair? We have been seeing you like this for long.
5 months.
5 months. 5 months. Oh. If it is comfortable, no problem. Otherwise, can we adjourn it for no problem? Yes. What is this matter about?
It is similar.
Taylor nature of cases, my lord, issue notice.
Issue notice.
Issue notice. Issue notice.
Both 2 and 3 also.
2 and 3. Learned DSGI 1 and 2. 1 to 3.
2 and 2.
Item 2, it is 2.
No.
I also send.
Union of India and the Chief Postmaster. Learned DSGI is requested to accept notice for 1 and 3. Emergent notice to the rest. Notice to 5 is dispensed in 3. Requisites in 3 days.
Item 4, date appeal 1857 of 2025.
I mean, submitted to withdraw.
What you have done? Why not happy with the court?
Single judge order, the honorable single judge order has been challenged. In between, we have complied the order of this. I have also attached the bank letter.
Oh, and this one. All this man. First one. See that body is number 2. All this matter along with the number 16811 of 2023. You want to withdraw matter?
Madam, I have also attached in this matter, we have challenged the honorable single judge judgment. So in between, we have complied the judgment.
Okay.
Complied the judgment, the bank letter also I have attached.
Learned panel counsel appearing for the petitioner bank has moved a memo seeking leave of the court to withdraw the appeal as having become infructuous. First one. Below. The memo reads as an memo dated 18/3 reads as an first one. In view of the above, petition is disposed of as having given choice. Petition is disposed of accordingly. The opposite party is not served.
Direct into press status of the
Requested to send a copy of this order to the office. Otherwise, then I can, we know.
Madam.
Yes.
Item 5 has been adjourned. Item 6, WPC 7411 of 2026.
Lordship, kindly pass over this matter.
Pass over.
Lordship.
Item 7, WPC 8013 of 2026.
May I please, your lordship? In this case, the wife of the borrower is the petitioner before your lordship. The borrower is dead since the year 2002, madam. On letter 7th to 26, madam.
Is it what kind of loan?
Loan it is a mortgage, it, madam.
What is the security for loan?
Mortgage or security.
What is the loan? Commercial,
No, not a personal loan, madam.
personal loan. How much?
It is 50,000 loan amount.
In 2002, it was 50,000.
2001, taken 50,000 initial has taken 50,000 loan.
Yeah.
And we already repaid 39,800 from annex of 2. I have annexed another proceeding was between the party. That is not the collateral, but incidental proceeding. The wife filed the defamation suit because they injured the reputation. In this proceeding, it finding has come to that there was 98,000. Some amount was pending
As on
in the year
7/2/26.
2012, madam.
2012, now how much amount? There is
Now,
notice 13 to notice now.
Yes, madam.
Come to Annexer
Annexure
1,
Annexure 1 is the demand notice.
4,31,008.
That is 4,31,608.
608.
Yes.
Huh.
After receiving the notice, immediately the wife sent a representation requesting to provide all the details so that she can be able to how the amount has come to the 4,31,000.
Huh.
That has not without
Wife, who is wife?
wife is the
How
wife.
she is concerned with the loan? A loan is a contract.
That is why he is the surety because from the
She is a surety.
might be the surety. It is not sure. What are the contents in the mortgage deeds is not aware. That's why it has been mentioned in the representation also.
No, who are you? Your wife, what is your right? It's a privity of contract between banker and the borrower.
In the mortgage deed, he was the witness to the mortgage deed. It has come to my knowledge from the earlier proceeding, my lord.
Mortgage deed?
I was the witness to the mortgage deed.
Your witness means anybody can be the witness, whether mortgage has happened or not. Are you a surety?
I am not sure, but client also could not confirm me. That's why, being an advocate, also I sent a notice to the concerned.
Who are you? Suppose if loan is between X and Y, can Z, who is wife of Y, can know all that? Your client may be your spouse, but where is the privity of contract?
That's why, madam.
I don't want my wife to know how much money I have borrowed.
But barely after the 9 months of the mortgage loan, he has died, madam. That's why.
Oh, husband. Let us say wife. We thought you are wife. You should say widow.
fact is-
English word is a widow. That is its
No,
past.
sorry.
That you will not say.
Fact is known to the bank also that the borrower is
We don't
dead,
know,
but
no?
their demand notice issued in the name of the husband
You
also.
take
But
notice. Yes, you take notice now.
my lord, or in between,
In between, if you want anything, 50% amount to be deposited.
my lord, my submission to the lordship that the entire it must be clarified to me the how the
Amount has come to this extent.
4,000. So I sought for some documents to be provided me. So in
You
between the
take note-
documents will be
You
provided to
take
me, my
notice. You pay 30% amount, we will stay there.
obliged.
All right. Issue emergent notice. First up. Application in IA number so and so supported by affidavit is filed seeking grant of reprieve, seeking reprieve against the coercive action in terms of section 32 notice. Dated
7/2/26.
7/2/2026, a copy whereof avails at Annexure 1. First up. Learned counsel for the petitioner very fairly submits that to show bona fide is her client to deposit a sum of deposit 30% of the demand amount in demand if a reasonable time is granted. And therefore, granted. First off, she also tells that if reprieve is not granted, she will be put to manifest. The widow will be put to a manifest injustice and hardship. First off, there is prima facie force in this submission. Next part, in the above circumstances, application having been favored, that the coercive proceedings pursuant to Annexure 1 or stay subject to petitioner depositing 30% of, we'll say that will be how much?
My lord, it is 1,20,000 around. Your lordship, lesser.
You 1,25,000 you will pay. 1,25,000. No, not 1,25,000. 1,25,000 into 3 will be 3,75,000. It must be more, na? 1,30,000. 1,50,000. 31 is 10. 1,60,000.
My lord, a little lesser.
In 3 weekly equalized weekly installments. 3 equalized weekly installments, filling which not only the interim order stands vacated, rescinded on its own, but petition runs the risk of dismissal on that ground. Okay.
Item 8, WBC 8297 of 2026.
Yes.
Simple query that plus property was auctioned in respect of a residential property. Other properties were sold and amount was adjusted against the loan. Now the only residential property out of 4 properties already mortgaged has been sold without notice to us.
You want disposal of
Yes,
application, IA.
So let them take it.
Let him pass the order.
Yes, my lord. That is
Petition
posted.
prior to
It was posted on 13/3 only. The
Counsel for the petitioner submits that. His application in IA number, diary number 430 of 2026 and 913 of 2024. Filed in
9-1.
miscellaneous case number 181 of
Set a
2024.
914 has been filed initially when there is no sale, my lord, because by that time the essay has been decreased and thereafter it has been restored in the month of October 2025
Correct.
after remaining from the DRT.
Correct.
Only now the present IA has been filed for stay of
But
the.
that is still pending. Whatever order will be passed, she should not have any objection.
Yes, small objection. Yeah, correct.
While in pending miscellaneous case number 181 of 2024 are kept pending indefinitely by the learned CJM Cuttack.
No, it's DRT.
But you have written CJM Cuttack.
The CJM's section 14 order has been challenged, but I don't press that. That order I have challenged in the
Pending
IA.
before the DRT.
Yes,
They have filed an IA only on 13/3.
Pending on the file of DRT Cuttack. And therefore a direction be issued for the early disposal. First one. Learned panel counsel appearing for the bank very fairly submits that there is no difficulty, submits that he has no objection for disposal of the said application, provided he is also heard in the matter. And in the matter, first off, he tells us that all contention should be kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next one, in the above circumstances, the DRT Cuttack is requested to dispose of, hear and dispose of the subject applications, preferably within a period of 8 weeks.
it can be done within 2 weeks only, because only one entire application. Yes.
Also,
Sorry,
it is not kept open.
ସେ 13 ରେ ଥିଲା
Next date is there.
ତାକୁ ଯାଇଛି ସେ ସରିଯିବ ବି ସେ
Petition is disposed. Next.
Let's say one thing. People also direct, we can deposit some amount before the DRT.
because sale has been done in 12/6/2024.
You do that.
Yes.
24 sale. Ebecar sale.
Item 9, WBC 8313 of 2026.
Petitioner is the guarantor. Sale notice is under challenge at annexure to base 16.
Sale notice.
Sale notice.
13-4.
No. 13-4 is pursuant to 13-2. 13-4 is the possession notice.
Possession notice. Sale notice.
Sale notice.
Sale notice.
The rule 9 of security interest rules.
Rule 8(6).
Read with rule 9.
Rule 8(6) and 9.
And rule 9.
Read with rule 9.
6 and 9.
Of the security interest rules.
Page 16 lordship kindly have a glance.
This is what kind of notice it, loan it is?
This is the notice to the guarantor.
What kind of loan you
Loan,
had?
what is
That
that?
CC loan, man. This CC loan has been cash credit loan.
Commercial.
Right.
How
Tax
much?
credit loan.
How much?
This is my so far the cash credit.
No.
5 lakhs in the year 2003 and thereafter in 2005 another 8,50,000.
Totally how much?
How much? 13,50,000. 13,50,000 and for business purpose that cloth has been there is a theft inside the cloth storeroom, my lord, for which a complaint case was filed regarding the deficient service by the borrower before the consumer court, and there is a award was passed by the dispute consumer forum for 6 lakhs rupees, my lord. Subsequently, they have preferred, the bank has preferred the appeal. Appeal is pending before the state consumer. while the matter stood thus, this notice was issued to the guarantor. And your lordship, the entire amount has, they have not mentioned, only they have mentioned 4,62,591.50 as on 31st December 2012 with interest. 4,62,000, page 16 in column number recoverable amount they have said. The date of sale fixed to 30th March, my lord.
30th of March.
30th of March.
What is your standing in life?
How are you?
How are you?
How are you having your livelihood?
I am the son of the
Guarantee-
loanee, my lord.
Loanee.
I am the son of the loanee, but there is a dispute between father, but for which he has separated from the entire property.
That's all it means. What is the property holding?
Property, my lord, is land and
How much? How much?
house, and they have reserved the fixed price, my lord.
No. What is your property worth? To consider granting interim relief, the standing of the litigant is an important factor. Therefore, whether you are income tax payer, whether you are a poor man working in a factory, laborer,
He is a supervisor, he is also a businessman.
businessman,
Businessman.
is he taxpayer? Income taxpayer?
Taxpayer that I have not. Yeah.
Businessman. Let him pay this.
My lord, what I was suggesting, it is on 30th and the panel council let it come on 26th because the notice is indicating that is of 2012. So now after 12 years,
It will
that
be
may not
much-
be the exact amount. So to assist your
Not
lordship,
what we thought was,
my lord.
if he gives that
My lord, he is the-
deposits,
Sorry, my lord, he is the guarantor. The father is the loanee. He is saying that there are dissensions between them.
no, that makes no sense.
Maybe.
Now that is what he was
No,
telling me.
he said that, that's true.
The stand taken by the person, that is why.
That's not your difference what bank should do. It is irrelevant for them. What is the, as on today, what is the amount?
That for that, let it come on 26th, my lord.
26 is too late, my 23rd.
Or 23rd. Yes, let it come on 23rd.
Call on 23rd.
Let him serve a copy of
Just
it.
name, just.
So that, my lord, the exact amount I
Issue
can.
notice that the panel council appears for
Eco bank, my lord.
go back. Is that 4 and 5.
All
The 2, 3, 4.
Till 5, my lord, I can take notice.
1 to 5.
No, you are up to 5.
5, 1, 2, 3, 4, 6.
6 is the lonely, my lord, let him appear.
Emergent notice to 6 returnable before 23. First of call on 23 for consideration of interim relief.
Well,
First of as on the next date of hearing, petitioner to state whether he is income tax payer and also disclose the property holding, including shares, debentures, and the like. Okay. Shares, debentures, bank deposits, and the like. Okay.
Item 10 has been adjourned. Item 11, WPC 8473 of 2026.
If I may please, my lords.
Yeah.
My lord, the petitioner is challenging the e-auction scheduled to be held today. My lord, what has happened in this matter is...
What is the bank pressure of loan?
Sorry, my lord.
OSFC. It's OSFC.
OSFC.
Commercial loan, industrial loan.
Industrial loan, your lordship.
So commercial loan.
Your lordship.
Ah.
My lord, in the year 2000...
1 second.
My lord.
How much amount you had taken?
My lord, 6,33,000 and 3,67,000.
How much
Totally
it will be?
10 lakhs, 10. No, total 6,70,000. Total 6,70,000.
When?
On 4/12/2000, my lords. 12/12/2000.
2000.
How much money you have repaid in that?
My lord, I have repaid around 5 lakhs, but not as per the terms and conditions. My lord would only see that as on date, the outstanding they say is 4 lakhs odd, whereas the interest that has been charged is 98 lakhs.
Yeah, it's a matter of calculation.
Yes. So, my lord, and now when they're seeking to auction the property, my lord, my respectful submission is they cannot do it directly in terms of section 29. Instead, they have to follow the procedure that has been contemplated under section 31.
29 provides for taking possession of the property.
Yes. taking possession as well as sell
also.
only of the industrial unit. If there is a mortgage, the process that has to be followed is under section 31. That is my respectful submission. The Honorable Apex Court, my lord, starting from the decision of Karnataka State Financial Corporation and onwards of the year 2008, has held that a mortgage cannot be done, a mortgaged property cannot be sold off by a corporation directly under section 29. The resort has to be through section 31.
31 is district judge.
Yes, my lords. Indeed.
In this case, to appear on behalf of the OSFC, that auction is posted today. They have appealed the OTS. OTS 11, they have appealed, but since they have not appealed, that not fulfilled the conditions of the OTS, it has been cancelled. Cancelled on.
That sale is cancelled.
No, OTS application.
OTS, all right. Now he is saying, in terms of section 29, you can only take the possession of the industrial unit.
Yes, that is too well. 31, I have to go to the district judge.
We have not fully completed our speech.
I'm sorry.
Unless some dialogue takes place, how will you be able to understand?
I'm sorry.
Two monologues do not make dialogue. They only clash with each other. He is saying, there is one 2008 Karnataka Division Bench judgment, Justice K.L. Manjunath and another. Do we have that judgment?
Yes, madam.
Is it by Justice K.L. Manjunath?
Justice Sinha.
Apex Court?
Yes, madam.
No, 2008 Karnataka, 2002.
That I do not have.
We have considered many aspects of the matter. I had appeared there.
Para 31.
Are you a surety or you are a borrower?
My lord, this is a proprietorship.
We are asking you.
My lord, I am the borrower, principal borrower. The property is not in my name. The mortgaged property, my lord, that which your lordship has asked. My lord, the answer to that is in paragraph 36, my lord.
Your property does not belong to you.
Property belongs to 4 brothers.
Who are they?
Me and my brothers.
So you are only?
No, not me. They are a different entity. They are other sureties. The property is not in my name only. The property belongs to 4 brothers, and accordingly, my lord, this is a mortgage. The mortgage deed, my lord, is not there because that is of the year 2000. It is not available, but admittedly, it is a mortgage, and not of the industrial unit. The mortgage.
No, Parliament intended to provide an additional remedy for recovery of the amount in favor of the corporation proceeding against a surety.
Yes.
Only in terms of section 31 of that, not under section 29 thereof.
Correct, my lord. So a mortgage, for a mortgage, my lord, for a mortgaged sale, which is not of the industrial unit, the mortgaged sale, which the industrial unit does not own, has to be necessarily done through section 31.
The one which is fixed for today.
Yes, my lords.
It is not for the industrial unit. It is not for the industrial unit, but for the mortgage property.
Yes, mortgage. My lord would kindly see annexure 11, page 59. My lord would see there are 2 parties. One is Nirod Kumar Sahu, one is Jaidev Sahu. The borrower is Nirod Kumar Sahu.
But you are partner. You are partners. You are partners in the business.
My lord, this is a proprietorship. This is not a partnership.
It is written.
Yes, that is a wrong mention. Your lordship will see the auction notice.
You both the partners had a well loan.
My lord, it is a proprietorship concern. It is not a partnership. It is a proprietorship concern.
But what is the difference between a partnership and a proprietary concern in this light of the matter?
In this light of the matter, my lord, the proprietorship concern is the legal entity, and the partnership would have at its remedies. The legal, the corporate.
Collectively, it is an entity.
Correct, my lords.
Correct. Now, there are more than 2-3 persons.
My lords,
They are partners only.
my lord, this is a proprietorship concern.
No, what?
Even if I admit for the argument, my lord, it is independent. The property that has been mortgaged, the corporate will apply, which is there in Para 36 of the judgment that the lordships are having. Please, I'm sorry.
No, not like that. Lifting the corporate veil is available in the case of company.
Correct, my lord.
It's a doctrine arising in company jurisprudence.
Correct, my lords.
But yours is not a company.
It is not, my lord.
Therefore, we need not travel to that paragraph at all.
My lord, because of the surety question that your lordships have asked, my lord, my respectful submission is this property belongs to 4 brothers. It is not that it is.
What is it? 4 brothers.
My lords,
Are they Hindus?
they are Hindus, my lord.
Then they are owners of entire property. Each one is owner of all property.
Correct. So therefore, the recourse is under section 31, where it has to be first, the share has to be determined and accordingly thereafter sold.
No. VDC. Any other point here?
My lord, those judgments, my lord, that in case of
Consider.
my lord,
In the case of Hindus, Mullah means Hindu law,
your lordship.
Raghavachari, Mitra, all 4 treatises on Hindu law, following Gautama Sutra
Yes.
and Vijnaneshwara's Vidakshara, they have held in the case of Hindus, where they hold a property, family property, each of the holders is the owner of entire extent of the property, unlike in Mohammedan law. Therefore, your contention that there are 4 sharers will not come to your aid. They will get their shares determined on partition. Still partition takes place. Justice Gajendra Kadkar said, each one is the full owner of entire property. If that is so, your argument does not avail to you. Any amount are you ready to pay?
My lord, please have the 20, please have annexure.
We do not have. We are asking you.
Yes, my lord, but the principal amount I'm willing to pay, my lord.
What principal?
My lord, as per their last OTS, they had categorically stated to us that you pay 4.5 lakhs and in case of default, you take further interest. But I'm willing to pay that amount with interest as per the letter of 2023.
We were not paid those.
At that time, I had not paid, my lords.
Right? Now, because fire is there, now your client has woken up with the heat. No, we don't.
For 26 years, my lord, in 2020 and in 2026.
26 years, you have misutilized the funds. And the industry has not worked.
I bow down, your lordship.
Object of State Financial Act is to boost industry, not for those who launder with the money. No case.
My lord, may I just for my lord, for my satisfaction, may I ask your lordships to have a glance at a very recent judgment of this honorable.
Give that.
My lord, paragraph 15.
1.5.
Yes, my lords. My lords have it?
Yeah.
May I read, my lords?
No, this section 31 contemplates property of surety.
Yes.
Here you are borrower.
Yes.
Where is the surety?
My lord, this mortgaged property is of the surety.
Surety means who? Your brother.
My brother and me.
Correct. Entire property it is.
Yes.
Therefore, I am telling you. Since you are not addressing to the principles of Hindu law, this problem is arising.
My lord.
In the case of Hindu law, right from Gautama Sutra period, every in the case of Hindu law, it is bit different from co-ownership of English law.
But they are all joint owners. They are all
not only joint owners. Each one is full owner of the property.
Yes.
This is the difference. Therefore, the property which is now given by way of mortgage, one person is the full owner of that property. One of the mortgagors is a full, because parties are Hindus. But that is not the case considered by Justice Brother Judge Shivo. That was a different case. This argument, this view itself is not addressed in there. Therefore, there is one very monism in law. All laws converge at a particular point, which J.G. Stark in international law discusses very beautifully. All laws converge at a particular point. He called it as doctrine of monism, like Advaita, etc. That way he considered it. Since Hindu law is not known to the quarters whichever, this question arises. Therefore, those who practice law, they should not say, I am banking law lawyer, I am service law lawyer, I am a criminal law lawyer. No. All law should be known to all lawyers and must be known to the judges. Therefore, we do not agree with you. But you are very fair and you come with preparation. We have seen you 2 to 3 times. So grateful. I have to send you empty-handed with those who come to this court with a lot of knowledge. We have to respect them. So, but at the same time, we have to abide by the law. Therefore, if your client shows the bona fide, then we consider whether we can make grant some reprieve. Those who come to this court with full preparation, with full knowledge of the case, generally we cannot send them empty-handed. We don't do that.
So grateful.
Yes. So ask your client, is he here? Ask whether he is ready and willing to show the bona fide. What was that amount in OTS?
Lord, OTS was
how much money? When?
2023, page 62, annexure 13.
23.
Page, annexure 13, page 62.
Its date is?
Date is 26/12/2023.
26/12/23.
Yes, ma'am.
About 2.5 years are over.
Maloj.
So how much money there they have shown?
4,43,610.
Now the amount due is how much?
1 crore plus.
1 crore 4,82,150.
Where is your calculation sheet?
That calculation is not with me, but so far as letter is concerned.
What is the rate of interest?
Document is not with me, that can only that document.
What is the rate of interest, brother?
My lord, 12% penal 2.
Yes, 12 plus 2.
And it has been changed from time to time, my lord.
But you have not you have not paid any amount.
My lord, I have paid payments, my lord. I have paid more than 10 lakhs during the entire tenure for the 6.5 lakhs loan. I have paid more than 10 lakhs and I have annexed the receipts, your lordships.
Now, is he ready to pay 30% of the amount? We'll stay the auction.
30% of the entire outstanding?
Entire amount.
For your term loan, the rate of interest is 16.5%.
Plus 2.
Plus 2.
It will be 18.5.
My lords.
Then the amount, it's arithmetics.
I bowed on my lords. My lord, I will only request the lordships that whatever, my lord, let the auction go on as scheduled. Whatever was the amount there, and let them consider in case the auction fails, my lord. Then in that event, probably they would consider his OTS because as long as that, so as long as that sword is there in his head, my lord, I don't believe that they would consider. So let the auction go on as scheduled. For to show my bona fides, my lord, I'll deposit 5 lakhs, my lord.
5 lakhs? What?
5 lakhs because that was the OTS amount. And
no, that don't say OTS. OTS is dead and gone now because you did not avail that. If you pay 30%, we will, otherwise we may dismiss the petition itself. No? So that at least auction purchaser will have clear-cut title. What do you say?
Well, so far as collateral loss, kindly have a glance to annexure 59, where that this decision is so far as that COLA.
Whether owners of property, all they are borrowers here?
No, my lords.
They are not.
No. There is one borrower and others are not.
Who is he? Father or brother?
Brothers.
Nirod Sahu is the.
Yes, Nirod Sahu is the borrower and he is one of the brothers. There are 4 brothers. And
Nirod is the eldest brother.
Eldest brother.
Your father is not there.
Is not there.
Then eldest brother will be the Karta.
My lord, had it
Presumption is that.
yes, had it been Hindu undivided property, yes. But in the absence thereof, my lord, to assume that it is a Hindu undivided property probably would not fall in my arguments, my lord.
Presumption is there.
Yes.
You mean to say presumption extends to only there being a Hindu joint Hindu family, not the joint Hindu family property.
Yes. Yes.
You take notice. Let auction go on. Yes. But it will be subject to outcome of the.
So far as my learned friend's submission is concerned, we are only taking industrial concern. That so far as lordship, for a moment, your lordship may kindly see Annexure 11, page 59. That has been specified. Alone. Yes, madam.
Only industrial concern.
Only industrial concern, my lord, which has been provided under section 29 of that, and we have taken our position under section 29 of it. Lordship, for a moment, lordship may kindly see Annexure 11, page 59.
You take notice. There's come with so much preparation. Issue emergent notice. Learned panel counsel accepts notice for all OPs. We are told that auction is scheduled on
today.
Scheduled this day, and therefore we do not interdict it. Call after 2 weeks.
My lord, interim application subject to outcome.
No, we will not say anything.
My lord, subject to outcome, my lord.
No, we will not say. Let us see. Even otherwise, it may happen because list pendants will be applicable. Therefore, but we will not mention that.
My lord, any
because
kind of
no bona fide on the part of your.
My lord, may kindly take it up to 10 lakhs. My lord, I can only make that offer, hoping that my client will pay it in 2 installments.
30% amount. We have, in fact, because of your very good performance, we are not in a position to dismiss it, to be frank with you. Now, because of his submission, that auction is confined to the industrial concern. Where is your case? That case itself will go.
No, that I was answering that.
Industrial concern.
No, it is not only an industrial concern. That is exactly my argument. That is what I was trying to say.
No, we will make it clear now. Because of his submission. Auction can be confined to the industrial concern.
Cannot be.
Why?
Yes. Please. Please have a glance at the ROR. This is an ODI ROR. This is an ODI ROR.
What it says? No. It is there, but does it find place in Annexure 11?
Yes, this is the property that they are talking about.
Annexure 11, industrial concern. That is the auction amount. That not so far as the COLA.
This is not included. This ROR is not included there.
ROR to the law.
This land stands in the name of Nirod Sahu, Pramod Pavan of the proprietors. That is. But the borrower is only Nirod. Yes.
Yes, that is the industrial.
That is the industrial establishment.
Yes.
So industrial establishment is existing over this land.
Industrial establishment is defined under the Act.
Under this Act.
Whether it is defined. Is it defined?
2C.
Industrial establishment means?
Lease, this is their lease your land. That we have to see the lease.
My lord, please see the ROR.
Don't say substandard argument.
My lord, the ROR categorically defines it as industrial and homestead. There is no distinction. The ROR is categorical about it.
No, whether industrial concern is defined because section 3 of the Transfer of Property Act defines 3 or some section. What is immovable property is defined.
My lord, industrial concern is defined as in 2C. May I read, my lords? I would have to. Industrial concern means any concern engaged or to be engaged in 1. The manufacture, preservation or processing of goods. 2. Mining or development of mines. 3. The hotel industry. 4. The transport of passengers or goods by road or by water or by air or by ropeway or by lift. 5. the generation or distribution of electricity or any other form of power. 6, the maintenance, repair, resting and or service of machinery of any description or vehicles or vessels or motorboats or trailers or tractors. 7, assembling, repairing or packing any article with the aid of machinery or power. 8, the setting up of development of an industrial area or industrial estate. 9, fishing or providing shore facilities for fishing or maintenance thereof. 10, providing weight bridge facilities. 11, providing engineering, technical, financial, management, marketing, or other services or facilities for industry. 12, providing medical, health, or allied services. 13, providing software or hardware services relating to information technology, telecommunication, or electronics, including satellite linkage and audio or video cable communication. 14, setting up of or development of tourism-related facilities, including amusement parks, convention centers, restaurants, travel and transport, including those at airports, tourist service, agencies and guidance and counseling services to tourists. 15, construction. 16, development, maintenance and construction of roads. 17, providing commercial complex facilities and community centers, including conference halls. 18, floriculture. 19,
complex. The commercial complex, etc. is there. Anyway, let us see. You take notice, you file your objection. Yes.
My lord, so therefore, just one submission. My lord, so therefore, as per the ROR, on the property that is scheduled to be auctioned,
Let us,
categorically stipulates that it is not only an industrial, but it is also homestead.
let us.
My lord, may I pray for any sort of protection? Because, my lord, the reserve price of the...
If you pay 30%, then
I'll pay 30% of the reserve price, my lord.
not with the 30% of the amount.
My lord, the amount is 1 crore. The reserve price is 26 lakhs.
Maybe.
My lord, the property value is 26 lakhs.
No. Property value is
26 lakhs as per their auction notice.
that is reserve price.
Yes, reserve price.
Reserve price is not the value.
So, my lord, so that, my lord, for my respectful submission, 30% of 30 lakhs, my lord, 10 lakhs, my lord. I'm assuming only to show my bona fides, my lord.
No, there is no bona fide. If your manner, the petitioner appears to be the little.
My lord, I am in absolute distress.
Anyway, let us. Yes.
My lord, subject to outcome, if your lordships can only
No,
reply, my lord.
that will affect the market value of the property, because once the court says subject to outcome, the auction buyers, they will take it for a song. That will be against your interest. Next.
My lord,
Yeah. Possible. Possible.
Item 6.
2 weeks. Yes. Next.
Item 6, WBC 7 for all one of 2026.
50% of the reserve price, if your lordships can consider, my lord. My lord, the entire reserve price in a Nolian account, if your lordships can consider.
Yes, yes. Next.
Great.
Sorry, girls, from my absence when the matter was called.
No problem. Yes, Mr. Parvati, this matter.
I'll preface, my lord, myself.
My lord, may I pray for a date in that matter, my lord?
22nd of April. Yes.
So I preface my submissions, my lord.
Yes.
And this is a more or less, my lord, mercy petition. Here the petitioner is a lady, my lord, whose second appeal before the DRAT, I'm sorry, the surface appeal is the DRAT was dismissed for default. Thereafter, my lord, she filed a restoration application stating that her husband was ailing, my lord. He was suffered from certain kidney ailments. He died during the matter when it was taken up. After that,
What is the loan?
It is past order in this case. In this case, past an order.
No, it was last week. It was listed. Unfortunately, it was.
Yes, that's very well.
So
Your client, I remember, you were a junior.
he had mentioned it after last.
It about 2 weeks, and then you came and mentioned that let it be had at least 1
month.
What is the loan amount?
Lord, here, my lords, the petitioner had bought a flat, my lords. She was given the assurance by opposite party.
Housing loan?
No, not a housing loan. She had bought a flat. Unfortunately, without her knowledge, this particular flat was mortgaged to 2 banks by the seller. One, my lord, she represented the petitioner that I have outstanding loan of Indian Bank. Please pay this amount and take over the flat. I paid that amount, and as per Annexure 1, my lord, I'll take that. Indian Bank gave a release certificate. I was not aware there was another loan outstanding of UCO Bank.
Could you ascertain by your...
No, my lord, because unfortunately, my lord, your lordship knows that the central registry was not there. I had applied for non-encumbrance certificates in 2013. All the certificates were said that there was no mortgage. Unfortunately, your lordship remembers, these mortgages were not registered and no machinery was there till 2016 when Section 20 capital A was introduced, where had the central registry and the SOCI was registered. So that thing was not available till 2019. But my EC certificates all showed that it was not encumbered with any banks, or no, this property was not encumbered. With that faith, my lord, I did it. My limited grievance, my lord, is I had filed, my lord, essay, my lord, before the DRT, my lord, against UCO Bank, because when they had published a notification, prior to that, I had come before this honorable court. Initially, there was a stay. That stay was vacated, I was directed to approach the DRT within 2 weeks.
That coercive action was under surface here?
Under the surface here. So accordingly, I moved the DRT. On a particular date, my lords, when my husband was ailing and he died before that date also, I'll take your lordship with the death certificate. That was dismissed for default. I had no knowledge of it because after that I had...
When it was dismissed for default?
No, that was dismissed for default.
DRT dismissed it?
My lord, DRT dismissed, my lord, Annexure 3 at page 49, my lord.
When you tell the date?
15/9/2023, my lords.
SA 74 of 2012.
SA 74 of 2021.
2020?
2021.
15/9?
15/9/2023.
SA number?
SA number 74 of 2021. That's at page 49 and it should be.
That was against what order?
That was, my lord, there was no order passed. I had not filed a SA, my lord, stating that I am a bona fide purchaser and this e-auction should not have been given. That those were the various stands. Lord, I've annexed also my SA, my lord, before this. And that was dismissed.
Auction took place when?
Auction has not taken place because I was covered by an interim order. Till date, no, there was no auction.
The dismissal, you went to DRT?
No, my lord. My lord, I was not aware of this dismissal, my lord, because if your lordship would kindly tell me.
What happened then?
After this dismissal, my lord, I came to know in 2024, I moved a writ application before this honorable court. Then this writ application was not entertained. I was asked to approach the DRT, my lords. And that order, your lordship would get, Lord, at...
You went to again DRT?
I again
for recall of the order?
For recall of the restoration along with the delay condonation petition. I stated that...
That was filed under which section?
That was filed, my lord, under section, my lord, 22G of the DRT Act. My lord.
That is made applicable?
That is made applicable, my lord, by virtue of, my lord, sir, that is made applicable.
Any limitation is there?
For a limitation of 249 days.
249 days?
My lord.
Any provision for condonation?
It's,
no provision.
No, there's no, Lord, sufficient cause has to be shown.
No, that is for 249 days.
No.
But how many days delay in this case?
In this particular day, 249 days.
But what is the maximum delay?
30 days. 30 days. 30 days is where the restoration has to be filed. If the lordship would kindly turn to page 82, that's the impugned order.
30 days. No. I want to know. I do not much know about the DRT Act, etc. That recovery of debts due to Bank Act, etc.
That is made applicable to this particular 22G. So far as restoration is concerned.
Let us see 22G.
Procedure and power of the tribunal, appellate tribunal. What you got?
22G, dismissing a representation for default or deciding the ex parte.
22G of the debt recovery and of the Recovery of Debts and Bankruptcy Act 1993. May I just hand over my book?
So that will give
22 is procedure and powers of the tribunal and appellate tribunal. Subsection 2 is the tribunal and appellate tribunal shall have for the purpose of discharging their functions under this Act. The same powers are vested in a civil court under the Code of Civil Procedure 1908 while trying a suit in respect of the following matters, namely, G is setting aside any order of dismissal or any application for default or any order passed by an ex parte.
So there is a provision.
There is a provision under the Recovery of Debts and Bankruptcy Act 1993. So this
But matter arises under the Surface Act.
Balance.
Whether this act is applicable.
Balance. I'll take that to your lordship. That is, my lord.
For example, for family code, under any order passed under 125 CRPC also can be taken to family code.
Balance. Your lordship, just give me a minute, 10 minutes. I marked it, but somehow that bookmark has.
No problem. These are all everyday learning. Take out Dr. Vijay Mallya versus State Bank of India. Karnataka region division.
I'm sorry. Thank you. 17.7.
17.7.
Thank you.
What does it say?
Not 17, section 17.7. Please, save as otherwise provided in this Act. The Debt Recovery Tribunal shall, as far as it may, dispose of the application in accordance with the provisions of the Recovery of Debts due to Banks and Financial Institutions Act 1993 and rules made thereafter.
Application means OA. Not application.
No, application under the Surface Act. Surface Act 17 makes this provision applicable to all proceedings under 17.
Whether any legal opinion, any juristic opinion?
I've not checked. I'm only placing the statutory provisions.
There must be already judgments because it's a very old act.
And added to that, I have taken recourse to Order 9, Rule 13 CPC. That is how I've styled my petition. So my limited prayer, Lord, for your lordship, will notice that there was sufficient.
Your dismissal was 15/9/2020.
My dismissal was 15/9/2020.
You applied for restoration on which day?
My lord, I applied, my lord, for restoration on in 2024 months.
No, there has to, because continuation of delay is 30 days.
30 days.
On which day do you know?
My lord, that was.
You said 249 days delay.
249 days. After 30 days is the limitation.
After that,
249 days.
249 plus 30, 279 days.
279 days. I'm sorry.
9 months, 9 days.
Almost.
Total.
That is the tribunal, learned tribunal has also detected, calculated. Hence, deducting 30 days from the statutory period, the petition is delayed by 249 days.
But there is a provision to condone delay.
The provision to condone delay, my lord, is inherent.
And the Limitation Act is not made applicable.
Limitation Act is made applicable.
Made applicable?
Made applicable to the limited extent of.
Where is that?
Order 9, Rule 13, Rule, your lordship would see.
No, Order 9, Rule 13 will not be applicable later. CPC will not be applicable later. It will have powers of the civil court is different meaning it is. It should follow, the provisions of the CPC shall be followed wherever that is the intent. Like representation of people to the extent possible. But that is not, there is no such section to my knowledge.
But the language says, my lord. The language will order the tribunal and the appellate tribunal
shall follow the, that is not the follow the, that will have power of the civil court.
As vested, powers of the vested.
That power
of to condone delay, my lord.
No. court, there are at least 2-3 judgments which say power of the civil court will be available to the tribunal is one thing. The civil court should follow the civil procedure code is another. Wherever they want it. For example, there are provisions in the Representation of People Act 1951. They say, as far as possible, the provisions of CPC shall be followed. There are such provisions. Then that is one thing. The power of the civil court is available even to the Tahsildar. So that does not make application of the court. But point is, power of the civil court is available does not mean
the entire CPC is
order.
Maybe the procedural part.
Not even procedure, only powers, substantive power. And the Supreme Court said it is not even 151. Powers of the civil court under the code does not amount to inherent power, because power given to civil courts under 151
is a special power,
or to the criminal court under 482. So High Court under 482 is not part of the code.
It's an extraordinary.
It is extra code power. Extra code power.
For the substantial justice,
etc. But that power is not there with the tribunal. And no power to condone delay. If they wanted the condonation of delay, they would have said the provisions of the Limitation Act, this, that, etc. Or because the purpose is speediest recovery of the amount. The 2002 Act is structured on the recommendation of T.R. Andhyarujina, who was a additional Solicitor General of India. Now what happened?
Now, Lord,
it says no provision for condonation of delay.
He doesn't say.
He says plausible explanation is not there.
My Lord, he says, Lords, from the perusal of record, it is seen that no plausible reasons, your Lordship is very correct, have been assigned in the MA applicant for condoning the delays, and as such the MA.
They told Vijay Mallya. I think Vijay Mallya, we consider one particular Dr. Vijay Mallya.
Unfortunately, Lords, I have specifically pleaded about my husband's death, about my mental condition.
No. Cause for condonation is one thing. Power to condone is another. You may have strongest cause for condonation of this. But if I don't have power to condone, then that will not come to your aid at all.
My humble submission would be, if it is not negatively worded, and the powers, like in some statutes, they can condone it for maximum for 1 month or for 90 days, not beyond that. Because the statute doesn't say.
Justice Manishwari Saab and myself. 2019 ILR, something like this. Now what happened?
Now that this particular SA stands dismissed.
Correct.
Because of this original order up to 2023 months. Now
the 23 order, original order is what?
Dismissal due to non-prosecution.
No, that's all. You were against, on what basis you went to the...
I went on the basis, my Lord, on a paper advertisement by the UCO Bank for sale of my flat.
Whether it is sold now?
No.
But it's
to my knowledge, it has not been sold.
Heard. Heard learned senior advocate Mr. Kora appearing for the petitioner. First time. He gave a thumbnail description of the facts of the case, which meant a deeper examination at the hands of this court. First time. There is a possible interplay of Surface Act 2002, DRT Act 1980.
No, DRT Act is 1993.
And the provisions of CPC as well. First time. Matter merits a bit deeper examination. First time. In the above circumstance, issue emergent notice. Any interim protection you are sought for?
I'm sorry.
But there is delay. You take notice in the event if...
the delay, my Lord, and that's my impression, my medical certificates about my mental health.
What is the reprieve you have sought for?
No, no further action.
Not to take any coercive action pursuant to Annexure 10.
Annexure 10 is a dismissal order of my restoration application.
For dismissal, where is the stay?
Sorry?
For
No.
dismissal order,
There's no state, not to take any coercive actions. Because now, my lord, I am without a essay, I am without any protection.
it is open to the petitioner to move this court in the event any new circumstance arises because of coercive action being pursued by the bank. Okay.
As and when they do it.
That's what.
Or my IA also may be kept pending.
IA is kept IA to be considered after service of notice. Okay.
I just pray for a date. I'll take notice by speed post.
No,
Because all these are
cannot give it the admission stage. Post immediately after service. In addition to taking usual steps, it is open to the petitioner to take a hand summons to the OPs. Yes.
And I'll get back to your lordship about the 30 days, my lord. I'm also not very.
There are 2-3 judgments where we have held there is no provision for condonation of delay. Just look into Dr. Vijay Mallya versus the State Bank of Mysore. This is AR 2019 Karnataka 23, affirmed by the Supreme Court. I was one of the benchmates there. Just look into that. There are other judgments also. Just looking. There another judgment is whether CPC is applicable or not. AR 1982 Supreme Court 935 something. There, Jyoti Basu versus Devi Prasad Ghoshal.
I'll get back to you.
Justice Chinnapareddy.
I'll get back to you.
Good judge.
But the main ground, Lord, as the lordship has said that no plausible reasons have been assigned.
The court proceeded on the assumption it had power. So at least we will examine. That 82 Supreme Court 983. Okay. Yes, next.
I'll get back to you. Greatly obliged.
Item 12, Lead Appeal 433 of 2025.
Item 12, Miller. I recall that matter when
80,000 rupees.
80,000 rupees. My learned senior friend, Mr. G, was there, Miller.
Yes.
Day before yesterday. In fact, we have also communicated on the same day, that is 17/3, 2026. Yet we are.
Who is the officer?
This is Collector Kata.
The collector addressed to whom?
You had addressed your letter to whom?
We have addressed to all, regarding the additional secretary to GAPG.
When the letter was sent?
It was on 17/3, Miller.
No response.
As yet, Miller.
What were orders in this matter?
This is order dated 16/3/2026 as order number 2. 16/3. इधर रिसीव के देखिए ना, देखो
by our order dated 16/3, we had said as at no other order was passed.
Personally, you must some time for that.
That will not happen. Your government does not care you.
My lord.
Because it does not care us only.
My lord.
How it will care its lawyers?
The collector has recommended our case to the Chief Minister's office so that.
But what happened to collector's recommendation?
Long back.
You other day, you took time.
Yes.
Saying the same thing.
Yes.
But they will not, you are all good people. But government officers are not good. They have taken, here is a widow. She has lost her husband. There is a recommendation by the district collector for 80,000 rupees.
In 21.
It will be less than the tips the government officers will give when they go to 5-star hotels. But people live in hutments.
Yeah, may I pray, Lord? After lunch, can it be? I'll take a chance. I'll take a chance. Honestly, we are placing the matter as per the records.
You threaten the officers. Tell them that we will not leave them that way. They will be made to parade here.
After lunch.
Warn them first. Show them our video. Yes.
Item
The
13.
widow, there is difficulty.
We are conscious, my lord.
And
we are not pressing in that angle.
collector very rightly recommended. Still the officers do not look into the grievance. What an audacity. They think that they are all still Mughals. They are servants of the people. Yes. Come after me. Yes. First over.
Item 13. Rate Appeal 1583 of 2025.
Here, my lord, there is a 2 days delay only.
What is on merits, Karan?
On merits, this is assailing the order of this Honorable Court dated 18/8/2025, my lord. In nutshell, may I place, my lord, in one minute.
Where is the power jurisdiction to pass the order? Come to para 38. The only point is no competence to pass the order. Establish the competence. What was that order?
My lord, for that, 1 minute, my lord. May I say? The present opposite party was deputed to the medical college, my lord, as a provisional engagement order issued on May 2024, my lord.
Yeah.
May I place page 35 for a moment?
Page 35.
Exactly.
Go to 35. This is the deputation order.
Exactly.
Deputation order made
so
by
they are in, my lord?
Made
by the
college.
Dean and Principal MKCG Medical College.
Deputation dated?
This is dated 22nd May 2024.
Deputed to what?
Deputed to assistant professor on deputation to the medical college.
What is deputation means? Deputation means lending official of one department to another department for a short purpose or a period.
In fact,
that has happened here.
Yes, ma'am.
This college sent him to whom?
My lord, they are working in the periphery, my lord.
In the
peripheral.
Periphery of the state.
Periphery of the state, my lord. On the same department.
Yeah.
Under the OMHS cadre, Odisha Medical Health Service, my lord. Because there was a shortage of teaching staffs in the medical college, for the timing it was the interim management. Whenever the OPSC will recommend the persons, till then these persons, doctors will continue, ma'am. That is well reflected in page 36. The next page, ma'am. Per moment it will clarify the terms and conditions of the contractual service. The point number 3 for a moment. The engagement shall be purely on temporary and on the year-to-year basis, tenure basis, and may be for a maximum period of 4 years, subject to satisfactory performance or till appointment of the doctors as assistant professor on regular basis through OPSC, whichever is earlier. While he was continuing as such since May 2024, there was an untoward incident, manhandling of some PG students for affair was lodged. That was the copy which has been given, details, photograph, the decisions. Keeping in view that untoward incident, Medical Council has taken a decision to revert back to their original place. But the language was used as terminated. That was the crux of the point.
Oh. It was not termination.
It was not termination. As of now also. Exactly. It is reversion, it is
position.
Repatriation. This may be called exact word, Miller. Page 73 for a moment.
To take notice.
Yes, ma'am.
Issue.
2 days may be condoned because.
But without notice.
2 days, if my lords will take the intelligence.
True. But without notice, court said, Peace Court said we cannot condone it. Any coercive action?
Yeah, exactly. They are moving further.
Issue emergent notice. First one. Learned DG, drawing our attention to
Annexure 4 Miller.
Annexure 4 submits that though it is not happily worded,
Exactly.
its intent is only repatriation of the employee and not termination. Semicolon. Learned single judge has construed the said instrument as termination, has accorded relief to the respondent, and therefore interference of this court is warranted. First off, the case is made out for deeper examination. First, issue emergent notice and stay of impugned order till next date of hearing. Yes.
Item 14, which April 2025 of 2025.
Miller, limitation is 925.
What's on merits?
Merits, my lord, that Norris Supradhan 1 day he has to be regularized, my lord, has passed.
Is it covered by judgment? Covered by our judgment? Which is that?
Last order that you have passed.
Last week order was passed.
Can you give that order?
I can give it, my lord.
Pass out.
Before lunch, my lord.
Yes, we'll revert in a couple of seconds.
Yes,
Yes.
Item number 19. Your lordships have adjourned it on the prayer of the electricity company council, Mr. Pradeep Mahanti, for 2 weeks. I only pray a date be fixed because yesterday he had asked me 30th of April if your lordship is, if that is convenient to your lordship.
30th.
30th of May,
March we have difficulty.
Then first week of April.
Put it on 9th of April. 9th of April.
9th.
14 Miller.
Yes.
Your delay is of 9 to 5 days. This is in respect of the arrear salary for the period 7/10/1998 to 22/2008. Basing upon the Union of India versus Tarsem Singh.
Tarsem Singh. It has been followed.
Yes, that preceding 3 years.
Correct.
From the date of filing. Here, my lord, the period of arrear is 98 to 2008.
98 to 2000.
Less than 3 years. And Swarnalata Sahu is followed in terms of Tarsem Singh.
In terms of Tarsem Singh, that is at page 30. That has been taken care of.
How will I know that?
Is it your case that Tarsem is not applicable or Swarnalata is not applicable to you?
That was our stand, Milan.
Have you
Because
taken up
they
that
have-
contention? Where have you taken up that contention in the appeal?
In the appeal memo.
That learned single
We have said that
only
in
applied.
belated service, the claim was rejected because they have kept mom for a quite long period.
How long they kept?
You know, since it is 98, they have filed it in the year.
No, your ground is only that it should have been calculated 3 years prior to this.
3 years prior.
That's all. Not that the links are not applicable.
The limitation point from 3 years. Notice. You take notice.
In both, Miller.
Huh?
Because limitation is there and.
Yeah, both you have to take. Issue emergent notice both on main matter and on the delay application. Returnable within 6 weeks. How many days of delay?
It is 9 to 5.
9 to 5.
It is around 3 years approaching.
9 to 5. 9 to 5 is too long a period. 3 years. Will you deposit, let me deposit 20 rupees. 20 rupees per day. We have adopted it. All you are aware of that.
It is for this financial year. After 31st, it will increase.
It increases.
No, my lords, when the days will be more, then the amount at the rate will be less.
No. You deposit.
My lord, may say lump sum 10,000.
10,000. How? No, there will be no yardstick. All our judgment, decisions, opinion should be normative. It should be the citizen should know why you have awarded. Like we are not Mughals. The judges have to do some things in accordance with some pattern. This appeal calls in question 11 single judges order dated so and so entered in respondents WPC number so and so whereby relief has been accorded. First one. Next one. Appeal has been filed after booking a long delay of 925
days.
25 days and application supported by affidavit accompanies the appeal memo seeking its condonation. First one. Since the delay is too long, come on. The appellant stroke applicants have to show their bona fide by depositing an unalterable sum at the rate of 20 rupees per day of delay with the registry of this court within 3 weeks. 3 weeks. First one. If amount is remitted, issue notice both on main matter and on the delay application. First one. If not remitted in time, the application is deemed to have been rejected and as a consequence appeal to first one. Post after 3 weeks. Yes.
Item 15, Writ Appeal 2027 of 2025.
That was the matter. Yes.
Your my lord, it is delay of 712. But the matter is covered by the Lordship's judgment.
Covered by judgment?
Yes, that Norris, that is WN number 1131 of 2024 dated 29/1.
Take up. Between State of Orissa and Narasingha Chowdhury, okay? Separate amount. This intra-court appeal by the, go to that impugned order.
Impugned order it has page
2011-23.
yes, right, 2011-2023, page 23.
Yeah, correct. This intra-court appeal by the state and its officials seeks to call in question a learned single judge's order dated 2011-2023 entered in respondent employees WPC number 36827 of 2023, whereby relief has been accorded as under next. Having the first next paragraph. The appeal has been filed after taking a long delay of 712 days, and an application supported by the affidavit accompanies the appeal. We are now seeking its condonation. First off, we have perused the application and the accompanying affidavit as well. First off, it is like things have been repeated in this here also. First off, rarely we come across an appeal of the kind filed by the state within the period of limitation. First off, delay is too long and explanation offered for the same is not plausible. Therefore, we decline to entertain the application. First off. Next paragraph. The above being done, still we have undertaken to examine the matter on merits. First, the subject matter of this petition appeal is substantially similar to the one in writ appeal number 1131 of 2024 between so and so disposed of on 29/1/2026, wherein appeal of the kind has been dismissed, and therefore on the principle of verity, this appeal too has to meet the same fate. First one. Next one. In the above circumstances, application or the appeal as well as the delay application are dismissed or rejected in limine. First one. The appellants to implement or the impugned order of the learned single judge and report compliance to the Registrar General of this court within an outer limit of 3 months without driving the respondent to avoidable contempt proceedings. First off, registry to send a copy of this order to the private respondents by speed post immediately. Yes.
Item 16, review petition 62 of 2026.
Item 16, my lord, I am appearing along with the previous counsel, your lordship may accept my additional
votes.
Along with the previous conducting counsel.
Their appeal, na?
My appeal.
Your appeal.
It's a review.
It's a review in which I am appearing today. Your lordship may grant me few days time so that I can get prepared and assist your lordship.
2 weeks at the request of arguing counsel for the petitioner. Okay.
Next to a small question.
And the interim order, your lordship has given me that liberty of depositing 10 lakhs. I have deposited, I have complied, your lordship, sir.
We are told at the bar that in terms of the interim order dated
26/2/2026.
the sum of rupees 10 lakh has been remitted. On which date?
My lord, it has been remitted on. It is on, my lord. 10/3/2026.
10/3/2026. First time. Counsel for the
opposite party in the review.
OP needs to verify.
I'm handing over
the option purchaser. It is only the bank can answer it.
OP bank to verify. OP bank to verify this assertion. Call after 2 weeks. Next.
Interim order to
Interim order to
bank counsel is there.
No. Good one. Yes, we'll see.
Your Lordship may only direct the registry to indicate my name principal.
To print name of Mr. Bose as appearing for the petition.
Grateful.
Okay.
Review petition copy may be submitted.
Yes.
You copy?
Yes.
Yeah.
By tomorrow, I'll do.
Okay. Copy and coffee, both.
Copy with copy.
But coffee has to come from my elder.
I thought. I agree. Yes.
Item 17, 18, 19 have been adjourned. Item 20, WPC 10636 of 2024.
Lords, the state has filed this writ petition challenging the order passed by the learned Central Administrative Tribunal.
Yes.
My lords, here case is that the petitioner was paid the pensionary benefits, but there was a delay for which interest has been given.
Padmanabhan case.
Well,
Yeah. What is the rate of interest given?
given the deposit interest rate applicable to GPF, that is as per the rules. My lords, in fact, except technically it is, nothing is there. Lords, because earlier, my lords, earlier, the petitioner, the present opposite party, approached the learned cat. Tribunal said, if file representation, they will consider it. That representation was rejected in 2016. Yes, my lords. That is, your lordship,
When he retired?
2005, my lords.
2005. When did you give him pension?
My lords, the gratuity was paid in leave salary, three components. Leave salary was given in 2009. And gratuity and other things were given in...
That gratuity means DCRG. Death come retirement gratuity.
My lord, that is in 2016, pension in 2015.
Pension was in 6/8/2015.
15.
Very fast you have given.
No,
you waited till he entered his grave.
My lord, in fact, from the beginning, there was litigations filed by the...
Who asked you to litigate? You should have gone, he worked for you and he retired. You should have gone to his house with a garland. You should have put the garland around his neck. I put the pension order in.
My lords, in fact, one wanting was there, information. He had held a house building advance. He was asked to submit the payment slips. He didn't pay in time. That is why...
House building advance from whom?
From government.
From you. You should have ascertained from your records. Who prevented you from ascertaining?
My lords, that is...
Take down.
In fact, that order which was rejected, his claim was rejected, was not challenged by the...
Claim has not been rejected. Your lordship can see their own list of dates and events. List of dates and events. In item 9, my lord.
This is a order against tribunal. It's a tribunal.
Central Administrative Tribunal, because he joined as...
Petitioners, being the state and its officials, are knocking the writ jurisdiction of this court for assailing the Cuttack Administrative Tribunal's order.
Central Administrative
Tribunal's
Cuttack bench.
Tribunal's order dated.
Dated, my lords, 14/3/2023.
Whereby with OP's OA number 260 of OP pensioners OA number 260/00556 of 2020 having been favored, the following relief has been granted. Looking. Next, just looking for one.
Right.
Para 8. Next. Learned AGA appearing for the petitioner vehemently argues that there was the petitioner retired way back in the year 2005. Semicolon. His leave salary was settled on in 2009. Semicolon. His DC RG was handed in 2015.
This DCRG method, that is 2016.
2016. And pension has been sanctioned in 2015. This is 2015. And DCRG has been ended in 2016. First off, he tells that for the delay broke, the fault lies with the OP employee in as much as he did not give the full particulars of the housing loan availed by him at the hands of the petitioners themselves. And therefore, directing the direction to award interest is unsustainable. Learned Counsel Sri so-and-so appearing for the OP vehemently resists the petition, making submission in justification of the impugned order and the reasons on which it has been structured. He draws our attention to All India Services DCRG Benefit Rules 1958 and the decision of Apex Court in OP Gupta versus Union of India 2012 for ACC 328, wherein interest on terminal benefits at the rate of 12% has been awarded when delay has been brooked. First time. So contending he seeks dismissal of the writ petition. Next one, having heard the learned counsel for the party and having perused the petition papers, we decline indulgence in the matter for the following reasons. Number one, the Apex Court in the DS Nakara versus Union of India 1983 or 84, something like that, 84 something important, has held that the terminal benefits payable to a retiring employee is not a bounty, but is a right. First off, this court has taken the view that the terminal benefits do constitute the property, and therefore withholding the same without justification is a violation of Article 300 capital A of the Constitution of India. First off, therefore, unless the pension is, when the terminal benefits are withheld on justifiable grounds, delay has to be met by awarding penal interest. Interest, reasonable rate of interest at a reasonable rate, if not penal interest. Next paragraph. Learned counsel for the employee, appearing for the employee, is right in telling us that there is an enormous delay and delay brooked in settling the terminal benefits, and that his client faced great difficulty because of this. First off, it hardly needs to be stated that after the retirement, pension is paid by way of consideration for the past service, so that the pensioner holds his body and soul together post-retirement. First off, this has not been kept in mind by the petitioners we have occasioned enormous delay in settling the criminal benefits. First off, the petitioner retired in 2005 and his leave salary was given only in 2009. First off, his pension was settled in 2016-15 and the DCRG was paid in 2016. First off, the contention that there were no full particulars of the housing loan concerned would not impress the court in as much as the lenders are none other than the petitioners themselves. And therefore, they could have ascertained what amount was due from the side of the petitioner, from the side of the employee. First off, this they have not done. And therefore, the impugned order is inexplicable.
From one.
Yeah.
His claim was rejected by order dated 8/9/2016, which he has not challenged.
By the petitioners, my lord.
Huh?
By the petitioners, not by the court, not by tribunal, my lord.
The last contention of Mr. Behura, that petitioner's representation seeking payment of interest was rejected by the petitioners. So, employees' representation seeking payment of interest on the delayed settlement of terminal benefits was rejected way back in the year 2016. And therefore, without laying a challenge to such a rejection, the tribunal would not have granted any relief to him. He is bereft of merits. First off, it hardly needs to be stated that Overseas is not an East India company, but India company. First off, the apex court in Bhupendranath Hazarika versus State of Assam 2013 has held that the state and its functionaries should conduct themselves as model employers. First off, next paragraph. In the above circumstances, the Hazarika 2013 to ACC 516. In the above circumstances, the petition being ultimately of merits is liable to be rejected with a cost of rupees 10,000.
My lord.
No.
From the beginning,
I have harassed him.
My lord, from the beginning, I have stated, my lord, expecting this.
No, Mr. Behura, he's a pensioner. 2015, he retired in 2005. In 2015, you have settled the pension. How he should survive?
My lord. That is why.
You tell me how he should survive.
My lord, he was paid.
Perhaps he would have. He was acting.
IFS officer. My lord, he is an IFS officer, not
IFS officer. So, what is that you want to say? With the cost of rupees 5,000.
My lord, 5,000 there.
Very low.
My lord, no cost.
No, first of all, dismissed. The costs having been made reluctantly easy. Have you paid everything now? Interest is paid when?
No, they are not paid at all.
First of all, the interest, the impugned order shall be implemented by the petitioners within an outer limit of 4 weeks, failing which
2 months, my lord.
8 weeks, failing which the interest awarded by the tribunal shall be doubled. And this additional interest shall be recoverable from the erring officials of the department. Okay. All right. Okay. Next.
Item 21, WBC 21030 of 2024.
Item 21, my lord. In compliance to my lord's view, I have intimated the same to my clerk and informed to be present before my lord and seized before my lord.
What is that matter?
That 2 wives
Two wives.
Pardon to
Let me ask presence of the party.
No.
I have
You to talk to your client.
because your lordship has opened a view. So it will be better. That decision may be taken in her presence.
Ask for the service.
You are not, your lordship not ask for personal appearance.
No. But after the service.
No. Kindly see our order. 10 to 20.
Pardon to mention, my lord. On behalf of Dr. J.K. Lenka, kindly pass over this matter after post-launch.
Pass over. But lady has come. No adjournment shall be granted. Okay? Okay. Pass over.
Item 22, WBC 22-488 of 2024.
Yes, sir.
Your not short question is that petitioner had participated in an auction conducted by the bank in respect of the subject property. The subject property was put to auction. Petitioner participated, became the successful bidder, then deposited the necessary, started depositing the necessary. But while auctioning, the bank did not disclose that a portion of the property had already been acquired by the Swaraj Board.
Acquired by?
The Swaraj Board.
Swaraj Board.
Swaraj Board. So when I had paid, by 30th of April 2016, I had paid 30 lakhs 25,000.
When the auction was held?
Auction was held because 15/3/2015. 15/3/2015.
For what amount?
For 60.25 lakhs. Then in phase wise, as per the directions, first, second, first, total by 30th of April 2016, total deposit was made 30 lakhs 25,000. 34/2016. Lord, at this juncture,
30/12/2016.
30th April. 30th of April.
April 34.
2016. So after depositing, the bank had not disclosed that a portion of the property had been acquired by the Swaraj Board.
When it was acquired?
We do not.
How do you say it is acquired?
Yes, that's it. The bank intimated on 4/5/2016, informed that 4/5/2016, that 50 decimals, but your lordship may kindly note, 220 decimals is the entire property.
220.
20.
If 60 goes, it will be
50. 50 goes.
50.
50 goes, it will be 170.
50 cents.
50, we call it decimals here.
Decimals.
Yes.
450. That bit.
Perfect.
Each 50 decimals.
This 50 decimals had been
acquired
by the Swaraj Board.
Bank intimated.
Bank intimated. 4/5/2016. Lord, instead of, thereafter I made a proposal that since 50 decimals has been acquired, you make a proportionate calculation. I'll deposit the rest and give me 170 decimals. Not that they did not answer anything. I had to apply.
When did you send that letter?
I proposed 5/5/2016.
The next day.
Very next date. Very next date, I proposed that you adjust it, make it 170, and I am prepared to take it. Proportionate basis, you calculate. Now, since they did not answer, I went to the DRT. DRT for the purpose.
In OA number?
Essay.
Essay number?
Essay number 4 of 2018. Where an order of status quo was passed.
On?
That 6/2/2018. 6/2/2018, an order of status quo was passed. So any further auction could not have been held. Now,
wait, status quo is not to hold the auction. Status quo is always with regard to possession of the property.
Right.
Possession of the property, possession of the property.
Neither they said possession or the status quo as on today shall maintain.
Where is the interdiction of auctioning of the property?
Anyway, so, but still then, they went off for auction.
They held the second auction.
Second auction, 22/2/2018. They held the second auction.
No.
That failed.
That failed.
Failed. Then 23/5/2018, they again went for auction.
23/5/2018.
5/2018. Yes.
That also failed.
That also failed. And one intergerum
1 second.
thing happened, Lord.
23/8/2018.
23/5/2018.
5/2018. Auction.
Second, technically the third, we can say, because the first. Yes. So, before this auction also, the DRT had again passed an order of status quo. I don't have the date, but I have taken the
status quo order continued.
Now, after two failures, they again held an auction on 24/3/23. Let us say about 5 years thereafter. 24/3/23.
Auction happened.
Their auction happened. The petitioner's wife participated and
she got the property.
Yes, got the property. So, after that, I withdrew the essay before the DRT.
Withdrew essay withdrawn on which date?
Yes, on 31/7/23. Then 28/10/23, bank issued the sale certificate in the name of the petitioner's wife.
Sale certificate issued on
28/10/23.
26/10.
26/10. I'm sorry.
26/10/23.
4/12/23 conveyance deed was executed.
Sale deed.
Now, between these dates, these happenings, something happened. When the bank auctioned the property and it was settled on 24/3/23 in the name of the petitioner's wife, thereafter, the petitioner made a proposal on 22/6/23 stating that you refund the earlier amount with interest and adjust it towards the
wife's payment.
22/6/23. 22nd of June 23.
What they say?
But they did not say anything. They did not say anything. They adjusted the amount.
They adjusted the amount.
Only the deposited amount.
Not interested. Your grievance is against non-payment of interest.
Now, when I filed this writ petition, I had relied upon Honorable Supreme Court's judgment, which Your Lordship had taken note of while issuing notice.
Yes,
yes, and said that the bank should have because bank should be extra cautious, should have disclosed that property has
bank should be or you.
No.
The KVA tempter applies to you also.
No, because how can I know the property has been acquired or not?
No. When they say you should have, that can be verified from the.
No, that is an admitted fact. They have admitted. I'm coming to that. Lord, when notices went, they filed a return. In their counter, they say that two things they say. Yes, they have adjusted the amount without interest, but they are not entitled to pay interest because they
are not liable to pay.
Sorry.
Yeah.
They are not liable to be to pay interest. But as purportedly, they sent notices to me to provide bank details to deposit, and I did not deposit.
They sent that notice when?
That is, your lordship sees counter. Get this time.
Bank sent notice on which date, brother?
First, it has been intimated to him.
First of
4/5/2016. When it came to our knowledge, immediately we have given it to him.
15 saying you take back your money.
Take back your money. And he did not give. Well, what happened? It is a loan where the relatives' property has been mortgaged. It is their own property. If your lordship will see the sale certificate, it can be visualized what has been happened.
The dispute is not regarding the sale or auction. There is no.
No, I am coming. Your lordship, thereafter I have given the communications through email, my lord, in the counter affidavit.
Brother, they said you give back your bank details. We want to put your money into bank account. Why you did not give?
That's right. Because at that time I was pursuing the thing that you adjust it on probation.
No, they do not agree with that. On the
they did not reject.
When it is sent, they have sent it on 4/5/2016.
My record shows 15/3/2016.
No.
It is
Your record is also
4/5, yes. 4/5.
Also 4/5 only.
Yes, 4/5/2016. But this 5/5/2000, very next date, I made a request. I made a request that you, instead of returning, you please adjust it. Sorry, not adjust it. Pro rata basis you.
No, that they will not agree.
No, they have not stated. They did not state it.
An auction where the bid is made. Auction is an offer. Holding of auction is an offer. Bidder is highest bidder. He stands in the name of acceptor.
Yes.
Okay.
Yes.
You accept it.
Yes.
Contract came into force. If you do not want to take the property as it is, you said, no, I don't want.
No, I don't say that I don't want it.
Then you say, you exclude that part.
Because they cannot give that 50 decimals to
No, that will not. Apportionment is not done.
No, because they cannot give 220 to me. Auction property, they cannot
pay all.
So
if you want, you will take wholly. If you do not want, do not take it at all.
So
that is
if they could have said that, I would have been satisfied.
Some company, because you made him to invest money.
No, my lord.
Did not disclose.
It is not the fact, my lord and senior is stated. Your lordship may see the documents.
No, whether it was the property which you auctioned.
Yes, my lord.
Was it acquired or not?
Thereafter, it has been acquired. The notice has been filed by the petitioner in annexure 6 of the rejoinder affidavit, which I could not able to get the instruction from the bank.
When it was acquired?
My lord, in 25/2/2016 only the notice has been issued. Your lordship, top of the annexure 6 in the rejoinder affidavit. My lord, senior is
I'm asking a question.
My lord.
Answer should be date.
Yes, my lord.
When it was auctioned, acquired?
My lord, in the year February 2016, notices has been issued to the owner of the land. My lord.
Which notice?
The acquisition notice.
That is 12 to notice.
Acquisition notice. 12. Our notice.
Yes. 4 notice must be
long ago.
Long ago.
It is not given to bank, my lord.
You were also not aware.
No, not aware. When it came to the knowledge, they went to demarcate the land, and along with the petitioner is very much present at that point of time. And when they went, they came to know that has been acquired by the storage board.
Yes, I know.
For that reason, it has been intimated to the petitioner.
1 second. When you informed the petitioner?
Immediately, my lord. 4/5/2016.
After auction.
Yes, my lord.
After auction.
After auction.
After deposit.
After deposit of the 25% of the amount.
No, 50% of the.
No.
Because as on 34,
yes,
they had already deposited 30.25.
25%. Thereafter, it has been deposited 50%. And he has not deposited the entire amount. At that point of time, when the land has been demarcated, at that point of time, it came to knowledge that it has been acquired.
Correct. But what is his fault?
My lord, there is no fault on his part.
Then you pay the.
At first, he is entitled to get the compensation till 4/5/2016, madam. He did not. He has deposited by 30/4/2016, and we have intimated immediately on 4/5/2016.
No, you made him to do a lot of exercise.
No, madam.
One second. Look, it is a question of auction.
Yes, ma'am.
He has to gather money.
Yes, ma'am.
And he participated in the auction. His property.
Yes, Lordship. See the sale certificate kindly. I am saying that.
It's your property.
Yes, my lord. It is father-in-law's property. Your lordship.
Father-in-law's property.
Yes, my lord.
Father-in-law is not he.
My lord, your lordship may see the sale certificate. Sale certificate.
Father-in-law is a different entity.
Wife has purchased the property subsequently, my lord.
Correct.
And the father of the wife is the
Therefore,
mortgage the property.
Therefore, he becomes father-in-law and he becomes son-in-law.
For that reason, they could not. They insisted to take back the rest property, my lord.
They proposed. You did not.
And for that reason, they waited, my lord. For that, we have not told. Bank has not told at any point of time. But bank has never told. Tell them that
different entities.
My lord,
Even wife in England till 1891,
yes,
wife was part of husband like her ardhangini. And if the husband were to beat the wife to death, it was considered as half suicide. Only in 1891 that law came to be amended, saying that wife has personality, therefore husband cannot kill her, although he can beat with a stick not thicker than the thumb of the left hand. Okay, anyway, in Indian law it is not like that. Wife is always held in highest esteem.
Yes.
Okay. And she has a personality.
Right.
Now, father-in-law also has a personality. Father-in-law is a person. Wife is a person. Husband is a person.
Yes, ma'am.
That is son-in-law. All they are different persons.
Yes, ma'am.
Therefore, that relationship has nothing to do with the discharge of your liability.
Yes, ma'am.
So you have to compensate him.
My lord, where is the fault of the bank kindly?
No, we do not know. Fault of the bank is you did not do entire exercise to ascertain whether this property is
by that time it is the physical possession. Has not been taken.
No, we do not know.
But for
you
that
proceed
reason,
against the government.
My lord, there is no scope on the part of the compensation amount gone to whom, my lord, kindly see?
No, question is
compensation
amount. Father-in-law.
Compensation amount, they have received the only compensation.
No, they means not the opposite party number 3.
Though there is no scope for the word they. You should say he. They means how many people? It went to the owner of the property, father-in-law.
Yes, may I submit, my lord, what I have stated in my counter affidavit? I cannot go beyond the counter affidavit. My lord, your lords may see, it has been auctioned on, the deposit has been made on 28/3/2016, my lord, only.
That is the 25%.
Yes, my lord. And it auction amount is 60.25.
I've given in my...
That everything is given, na?
Yes, everything has been given.
30.25 as on
30/4/2016, 30,25,000.
Only question is simple question now.
My lord.
You say we did not know that it was acquired.
My lord.
That is your contention. Up to auction happened and he paid 50% of the amount, little more than that, is not in dispute.
That is not dispute. Yeah. My lord, when it came to the knowledge, before completion of the sale, before issuance of the sale settlement, before deposit of the entire amount, immediately it has been intimated to him.
Correct. But you made him to participate in the...
Yes, my lord. On 4/5/2016, after 1 month only.
That is?
30/4/2016, he had deposited the amount of 30,25,000.
Correct.
And on 4/5/2016, bank has intimated him that
take back the money.
We are ready to refund the amount. You give the details and we would refund it. Since it has been acquired, part of the property has been acquired by the storage board, we cannot give you the entire property. And when the auction has been made for the entire property, we cannot give it by...
We understand.
My lord.
We can't.
And
you could have given his anyway.
He did took it. And the same. And on 2017, again we have requested him several times by giving mails.
No, interest may not be payable, but the suffering that he underwent
And he was in possession of the property. He is in possession of the property and the entire property throughout the period.
No, how you made him to participate in the.
They have sought me the copy of the rejoinder on 17.2. I have sought for the instruction those documents they have given in the rejoinder. Your Lordship might keep it less.
No, we will not keep that. That way we never do. That way we saw before he started documentation.
Yes, ma'am.
We're not here to wasting time of the court. We don't have control over the time of the court.
Your Lordship may allow me, I will submit along with my counterpart. Your Lordship may see the annexures.
What for annexure? This is the only point.
Yes, ma'am.
No other argument at all. We'll not hear you on our point. What is that? Endlessly till the cows come
because
back.
It has been issued on February 2016 and thereafter it came to our knowledge. Immediately we have given the letter to the bank, to the auction purchaser to...
Why you made him to undergo auction?
But because it is not within the knowledge on 17.
For your ignorance, why he should suffer?
And only in 2016 the notice, it came to the knowledge of the bank that there is a notice.
You recover that money from the father-in-law.
It cannot be.
Well, then you pay it from your pocket.
Well, now the property has been sold and his daughter is, the father-in-law's daughter is only in possession of the property. Nobody else. Other than them, they are family members. So nobody else.
Reasonable amount has to be paid because you did not do your duty. There is one rule. Which is that rule? Rule 9?
No, yes, rule 9.
Yes.
Sub-rule 7.
Sub-rule 7.
How does reading it slowly, my lord?
Read.
Your lordship will take this.
No, read. No problem. Just
where the immobile property.
Another book you take that, surface C.
Where the immobile property sold is subject to any encumbrance.
Read.
The authorized officer may, if he thinks fit, allow the purchaser to deposit with him the money required to discharge the encumbrance. And any interest due thereon, together with such additional amount that may be sufficient to meet the contingencies or further cost, expenses and interest as may be determined by him, provided that if after meeting the cost of removing encumbrances and contingencies, there is any surplus available out of the money deposited by the purchaser, such surplus shall be paid to the purchaser within 15 days from the date of finalization of sale. So, my lord, question is, he did not know, is not equally, as your lordship rightly pointed. I also had no fault at that time.
But how is he, how are you? What is your terms of relationship with father-in-law?
Father-in-law?
Yes. What
that's a company, my lord. That's a company. Opposite party number 3 is a company.
Company of whose company?
Well, where the MD is my father-in-law. MD is my father-in-law.
Company, it is more like Solomon and Solomon, all one.
But that is a fact which that is on record. And you say,
father-in-law, perhaps your ego is too much hurt in all this. Therefore, your client has come before the court. Question of ego trip appears to be. Anyway, you wanted the bread. Bread your wife has got. You are happy with that because you said, whatever amount is payable my wife, you adjust that money to her place. Therefore, you wanted retention of the property in the family and the property accordingly retained.
No, that they have done. I am saying
interest you cannot claim because they told you on 4/5/2016, take back your money.
Yes.
You did not take back.
No, that is what I'm saying. We pursued that.
Why did you pursue? Essay. Then you should have continued with the essay only. Why did you withdraw it?
No, because I became successful. The wife became
Wife success taken is taken as your success. That's very good. Then why did you recover the essay? You should have prosecuted essay.
Lord, here is a case, Lord. I leave it to your lordship's.
No, ultimately everybody lawyer will leave it to
why I'm saying, Lord, the bank charge, money was with the bank.
The money was with the bank because you did not give your details of your account.
Is it an account? Lord, I am an auction purchaser.
Correct.
All my details are with the bank.
That you did not do. You said, you said, see, that was not your conduct.
No, they could have sent given back the money.
All right. You should have sent a letter. All my credentials are with you. My horoscope is with you. Do whatever you want to do with that. That was not yours. That was not yours.
Could have done. But the question is that saying that I did not know is
whether that was auction is as is where is basis.
Yes, madam.
Where is it? Read the auction notice.
And that is not with me,
Then
madam.
how do you say yes?
We can find it from the sell certificate.
Madam.
Of course.
That is written in the sell certificate.
Scheduled property, this says, this is for wife.
Yes, madam.
No, earlier.
Earlier,
Your advertisement.
Here I can give it by tomorrow, madam.
No question.
Madam, because it is an old one, for that reason I am not able to
have
give
been
it.
ready with you.
Earlier was as is where in basis, my lord. Everywhere it is stated the as is where is basis. And I have stated in my counter affidavit, they have verified the documents, thereafter they participated and everything has been done. And when it came to the knowledge, because the notice has been issued to them.
Security property was put to public auction on 15/3/2015. Kindly be seated. And the petitioner happened to be the highest bidder in a sum of rupees 60.25 lakh, of which he paid rupees 30.25 lakh as on 30 April 2016.
Yes.
First, the bank sent a letter dated 4/5/2016 to the petitioner to the effect that 50 decimals of land were acquired for the state sewerage board, and therefore he should take back his money by furnishing bank account details. First, next paragraph. Petitioner sent a reply dated 4/5/2016, 5/5/2016, saying that the said amount may be adjusted if auction takes place. How auction would take place? There was no auction at all.
So how it could be anticipated?
Where is that letter? How it reads? Let us see.
Letter is the chief. Usually 5/5.
Your 5/5 letter.
Just once.
Letter dated 5/5/2016 told the bank to confine the auction to the remainder of the property by proportionately reducing the bid amount. First one.
Annexure 7 of the rejoinder says that.
But it says it cannot be adjustment because wife was not in the scene.
No. I say, I understand that out of 220 decimals, 50 decimals has been acquired by the Swearers Board, state government. Therefore, I request you to please give me rest area so and so, pro rata basis.
For rest,
that's not area. First stop. The bank, we are told, did not respond to this. And therefore, petitioner filed essay number 4 of 2018 before the TRT Cuttack. What was your direction? Direction is to give the property. Essay was for what direction?
For interest.
Seeking.
I'm sorry. For giving the 170 decimals.
That is what. Seeking an order for delivering remainder of the property, that is 170 decimals. First, the DRT granted status quo order on 6/2/2018 that was eventually continued from time to time. In the meanwhile, second auction was held on the second auction was notified to be held on 22 February 2018. And third auction on 23/5/2018, which did not materialize. First, next paragraph. The fourth auction took place on 24/3/2023 in respect of 170 decimals of secured property, 50 having been already acquired for the benefit of sewerage board. First, petitioner's wife Srimati Ramya Rani, being the highest bidder, secured the property in the said auction by remitting the bid amount. With this development, petitioner unconditionally withdrew his essay on 31/7/2023. Whether did you say we are withdrawing and will pursue our remedy for interest, etc.?
Plain and simple, plain and simple.
First, learned counsel for the petitioner very fairly, on being asked, very fairly tells that it was an unconditional withdrawal. First, he tells that for retention of the money, for unjustifiable retention of the money.
Sorry, we said that it has become infructuous because of the. Would you like to have a?
Then your case will be still worse. If it is infructuous, means you are happy with the freedom.
Why should I not have? That your worship. He has noted the contention.
Prayer. But you're on the ground that the same has become infructuous. Infructuous. He tells that at least the interest should be directed to be paid to his client for the agony and ecstasy which he was put to. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we grant marginal interference in the matter as under and for the following reasons. 1. The bank had put the entire security property at measuring 220, kindly be seated, 220 decimals on 15/3/2015 without disclosing that 50 decimals of the same were acquired by the state for the sewerage board. First, the version of the bank that it did not have any knowledge of acquisition is irrelevant. When fact remains that the petitioner was made to participate in the auction,
the date is not 15/15, it's 15/16.
15/16.
Yes, yes, bank issued advertisement auction on 23/1/2016. Not correct, man.
16. Above also 16.
Because bank cannot take it after 1 year.
First,
16.
the contention of panel counsel appearing for the bank that the subject property belonged to father-in-law of the petitioner also would not come to his rescue. First of all, in law, comma, in-laws are in-law, comma, in-laws have independent personalities. First of all, father-in-law is a person, comma, his son-in-law is a person, and son-in-law's wife is also a person, independent of each other. First of all, merely because father-in-law is the owner of property, comma, which his daughter has bought in auction, comma, no attribution can be made to the petitioner unless a clandestine arrangement is demonstrated inter se. First, that is not the case of anyone. First, for ignorance of the bank, comma, a citizen participating in the auction cannot suffer. First of all. Next paragraph. The above view gains support from the text of Rule 9.
Rule 9, Surface Act. It is not Rule 7. Rule 9, Sub Rule 7.
Rule 7 or 9/7?
Rule 9, Sub
Rule
Rule
9, Sub Rule 7.
9/7
9/7.
of surface rules.
Surface rules.
Security Interest Enforcement Rules.
Security Interest Enforcement Rules, year
2002.
2002. You reproduce them. Below that, ordinarily, it is the duty of the bank to make all reasonable inquiries relating to the position of the secured asset before it is put to public auction, so that the participant in the auction would not be put to prejudice. First, we hasten to add that the doctrine of caveat emptor also plays a role, and therefore the responsibility of the intending auction buyer cannot be completely lost sight of, especially when the property belonged to his father-in-law and later he is retained in a public auction by petitioner's wife, who is none other than his father-in-law's daughter herself. First of all, what reasonable efforts, reasonable inquiries were made before participating in the bid, the petition ever meant militantly lack. First, be that as it may, justice of the case warrants that no interest be directed to be paid. Semicolon. However, some solatium be paid to the petitioner who was made to participate in the public auction and deposit the money. Public auction that was held on 15/3/2016 for a sum of rupees 60,25,000, of which 30.25 lakh, a sum of rupees 30.25 lakh was deposited by him as on 30/4/2016. First term. Next one. In the above circumstances, this petition marginally succeeds. A direction issues to the bank to pay to the petitioner a lump sum of rupees 50,000 within 2 weeks. Within 2 weeks. Record from this thing. 4 weeks. 4 weeks. Record from this thing. Failing which, an additional sum of rupees 250 rupees shall be payable per day of delay for the first month and rupees 500 for the days next following. First one. Cost is made easy. All right. Okay. What is withdrawal now? Password method.
Item 12, writ appeal 400/2025.
What have you done?
My lord, I have taken all possible endeavor to ensure that about this release and updation. So, but the collectorate is concerned Cuttack. So, in fact, it is kept pending with the GAPG department, my lord. And no action has yet been taken. This is before the.
Mr. Madhu, you could have talked to the chief secretary then only.
I could not able to contact.
GAPG, GA department?
GA department. That is pending, but they need just some more time.
Be contacted. Secretary GA.
Secretary GA. Secretary was on meeting. I could able to talk to that ADG law. They are saying it is, sir. Give us something. I have sent it on WhatsApp also.
So what should be done now? When instructions are sought for by the government lawyer, if not furnished, that amounts to coming in the way of judicial process and therefore contempt.
Can it be tomorrow?
On Monday we will have this matter.
Monday.
By that time we should bring some order here. Okay. Hopefully about releasing that 80,000.
I am positively, I am taking, even I am skipping my lunch meal.
In this one, in our order dated
This is order dated.
16/3/2020.
Yes.
We had said as that. Next paragraph. As the above order makes it clear, there was a recommendation by the collector of Cuttack for payment of rupees 80,000 to the petitioner. Petitioner or
in favor of petitioner's husband.
Petitioner's husband.
Sir, appellate husband.
For
Widow of the deceased.
toward the medical expenses, treatment.
What treatment?
Medical expenses. First of all, that recommendation was made on
21 February 2021.
21 February 2021. And now we are in March 2026. First of all, 5 years have lapsed, not even a leaf being turned. First of all, this is not a happy thing to happen with a welfare state. When a citizen who was ailing, now he having died, his widow is before the court. First of all. On the next one, on the assurance of learned AGA that the matter would be looked into on a war footing, and with the hope of some reprieve being granted to the petitioner widow, appellant widow, appellant widow. We are calling this matter on Tuesday.
24th.
24th. Tuesday. First, a carbon copy of this order shall be shared with the shared with the learned AGA, who in turn shall confer with the Chief Secretary of the government of the state. First, if nothing happens on the next date of hearing, something would happen in the court. We may direct 5 lakh rupees court, something like that. Okay, tell them. Not 5 lakh, 4 lakh, because 80,000 into 5. 5 years are over now. So it will be 4 lakh. Yeah.
So item 21, WPC 2103/2024.
May I please, Lords? Challenging the order of the Central Administrative Tribunal.
Mr. Lenka, we had last time told to have a negotiation and you to otherwise nobody will get.
Correct.
So why are you against initiating it?
Well, that other lady is also here.
Miller?
Have you taken instruction from your side?
My client told that we left to your lordships to decide.
No, always the Constitution itself has left it to be for us to decide. We will do that, no problem. But they have to walk an extra mile towards each other with olive branches.
Lordships.
Is it not? We will call this matter in chamber. On which date you will bring them?
My lord, your lordship.
We'll have chamber hearing.
No, please.
Since my client is residing at present Jamshedpur, lordship give some 10 days time so that we will fix the matter in the chamber so that we.
Yes. But your client has come from which place?
Bhubaneswar.
Bhubaneswar. No issue.
What is he? But his client.
My lord, this is a case of family pension. Your lordship knows my problem. That's why I have called though your lordship not passing order, I call her. So that if any order will be by my lords, that should be implemented, my lord. That's why I have called her.
This is a fit case for amicable settlement. To hold talks for amicable settlement. There are such instances even in the Supreme Court judgments. Okay. Both the sides, having argued the matter for some time, graciously agree with the suggestion of this court that there being some elements of possible amicable settlement come on, chamber hearing can be done in the matter. First one. Next one, in view of the above, call this case
First week or second week?
whichever.
First week.
First week of April. Not 8th of April. 8th of April, all right. Mild. Right? 8th of April at 2 p.m. All right. A carbon copy of the order shall be shared with learned advocates appearing for all the parties.
You'll also directly to produce the record.
We have made some order last time about that. Yes, we'll just keep them with you so that we will look into it.
16 to
8th of April.
In presence of both the
Both the sides. Okay.
My presence will not.
Huh?
Yes, very good.
The presence of panel counsel,
For accountant general. For accountant general.
accountant general, panel counsel for the copies of the accountant general is noted. He is requested to hold back, hold with him the original records, stroke files. Okay.
Item 23, WBC 23733 of 2024.
Is a covered matter already from conversation from CPF to GPF. You will also
But this is not a covered
the judgment on 10th March.
Let me place my.
Same batch ke same order.
Let me base.
I have a glance at last order.
What is the hurry?
7th January 7th. You will see directly.
I am also referring that judgment, my lord, your lordship's order. I am also referring that judgment how my case is different. Why I am out of that group. Well, kindly see.
What was the matter?
My lord, this is the petitioner is a KV employee.
We heard this matter the other day.
That is another fact, my lord. My fact is here. I have that's why I have filed alone. My lord, this is a case where the KV employee joined as librarian the year 81, my lord, when there was no other scheme than CPF. 16/11/1981. So there is no other scheme than CPF. Then, my lord, in 88.
81 as what?
As librarian in Kendriya Vidyalaya. My lord, my service book is also there. Joined till 88, my lord, there was no option because only two choices, then only options. In 1988, that Kendriya Vidyalaya Sangathan, my lord, kindly see that.
What happened? Tell first, then we look into it.
My lord.
81, 88, what happened?
There is a circular office memorandum of the central KV organization that you have to give option in writing to the head of the department for coming or whether you want to be continue under CPF or you come over to GPF. Well, that's the case.
Circular dated
88.
1988.
1988.
What it said?
My lord, it says, my lord, there is a deeming clause.
The option whether to be in CPF or in GPF.
Or GPF. In writing, you have to give.
Yes.
My lord, that's in para 2. I have also annexed but lazy, that's not legible. It has accordingly been decided that persons joining service in the Sangathan on or after 1/1/1986 shall be governed only by the GPF cum pension scheme and will have no option for CPF scheme. However, for all CPF beneficiaries who were in service on 1/1/1986, the decision taken shall be implemented in the manner hereinafter conveyed to the concerned head of office principal by 31/989 in duplicate. In the form enclosed, one form may be sent to this office while the other kept with the personal records of employee concerned. If the employees wish to continue under the CPF scheme, if no option is received by the head of the office principal by the above date, and this office through them by 28/2/1989, the employee will be deemed to have come over the pension scheme. But this is the provision of law. But in my case, how I am different from that group, my lord. I'll kindly see the counter. They have filed before the tribunal, also before this honorable court. I have annexed and annexed 22, my lord. Kindly see the counter. I'm referring page 24, para 5. There was no delay. In my case also, I can ascertain that it is humbly submitted here that successive representation filed by the applicant will not save the limitation which are intentionally and knowingly submitted and filed by the present applicant to save the limitation in filing this original application. So I have given sufficient number of representation to bring over me to the GPF scheme, my lord. They have not acted upon, so there is no occasion me to file a
Your first representation was given when?
My lord, before my retirement, from 2009 onwards, I have not annexed because they have admitted. I have given several representations.
2018, after retirement of 2 years.
Yes, that representation because I know, I can also submit. I am against the wave, I know, but still I am before the infinite wisdom and I can. My lord, kindly see that representation which my learned friend is referring, I have filed, and after retirement I came before this Central Administrative Tribunal. They have to, my lord, this consider culture. They have directed to consider, then only they have passed a order. Otherwise, I have no order to come before your lordship to challenge that why I have not come over to the GPF scheme.
No.
That is the real practical difficulty here.
No, read section 21 of the Administrative Tribunal.
That's my lord.
Where order is passed within 1 year from the date of.
Yes, I have come.
Where representation is given, but no order is passed.
Yes.
Then within 1.5 years, you have to come before the president.
That is my case, my lord. My lord, kindly see I have given the representation first, then the tribunal stated.
Now that itself is delayed.
No,
representation should have given.
Yes.
On which day?
My lord, that is.
You gave it 2 years after the retirement.
Because, my lord, I have given several representations. They are not acting upon.
Where are?
That is what we
are asking.
Yes.
So one representation.
They have admitted.
Oh,
because
first representation was given.
My lord, that I am told that he has given from 2008 onwards when he was at Chhattisgarh, because they have admitted. It is humbly submitted here that successive representation filed by the applicant.
Means what? Which is the first representation? You have to make out a case.
Yes, 2008 I am told.
Where is that?
My lord, be that as it may, I am saying, my lord, what I am referring to. My lord, kindly say that where I have never opted for CPF scheme. That is also in the counter they have admitted. My lord, that portion I will draw a lordship's kind attention that they have admitted.
One second.
My lord.
What is the consequence of not exercising option?
Because there must be a written letter, written request to the authority.
No, we are asking you.
Yes.
What is the consequence of not exercising the option?
Then I have automatically come over by operation of law. I will come over to GP. That is the poem says. My office memorandum says that.
Where is that?
Well, that I will draw to you. Now, the legible copy I am reading. In the 51st meeting of the Board of Governors of the Kendriya Vidyalaya Sangathan held on 31st May 88, it was approved that Kendriya Vidyalaya Sangathan will implement mutatis mutandis the decision taken by the Government of India on the recommendation of 4th Central Pay Commission for its employees for changeover from contributory provident fund scheme to pension scheme in the manner as indicated in the Ministry of Personnel, Public Grievances and Pension. It has accordingly been decided that persons joining service in the Sangathans on or after 1/1/86 shall be governed only by the GPF pension scheme and will have no option for CPF scheme. However, for all CPF beneficiaries who were in service on 1/1/86, the decision taken shall be implemented in the manner hereinafter conveyed to the concerned head of office principal by 31/989. In duplicate, in the form enclosed, one form may be sent to the office while the other kept with the personal record of the employee concerned. If the employees wish to continue under the CPF scheme, if no option is received by the head of the office principal by the above date, and in this office through them by 28/989, the employee will deem to have come over to the pension scheme. The head of office and principal are to be forward one and lot options exercised by the employees for retention of CPF scheme received by them to reach Sangathan office latest by 28/989. Where no option to continue under CPF scheme is received by them from any nil report be sent to due date like 28/989. So if you have not exercised your option, you are deemed to have come to the pension scheme. My lord, in my case, how my case is different, in the counter they have admitted there is no writing. There is no such request from the applicant to continue under CPF scheme. But
yes, tell.
But they're creating a secondary evidence stating your service book is the primary evidence. And where is the deduction of CPF continue till your retirement? That is the only case they have preparing for them. My lord, there are a lot of judgments are there. Supreme Court, your lordship's view is also that if I have not given any option, and that is a deeming clause that everybody who has not given the option will come over. In the legal fiction is, if you want to be in the CPF, then you have to give in writing.
That I want to continue with the same.
My lord?
That I have to continue with the
same. CPF, you have to give in writing. Otherwise, my lord, everybody should be come over to the pension scheme. It is only between 80 to 88%. 988, because these persons, those who are engaged or continuing, they have only two options, whether CPF or GPF. After 86, there is no question of CPF. So I have never opted for a CPF.
But all through received everything on the CPF basis only.
The contribution was only for CPF.
That is my point. Before your lordship, I will show that Supreme Court says that even if there is a deduction of CPF, when there is a beneficial legislation, and that is the authority has to himself deeming in taking the deeming clause, that is on the fault on the part of authorities not to bring over to the GPA, because I have never opted. They have not produced a scrap of paper. Whatever your lordship's order that my learned friend is showing, that is they have a request specifically stating we want to continue under CPF. And this case, my lord, there is no such letter, and because they are saying the documents, my lord, in paragraph in page 27. In page 27.
Yes.
My lord, in page 27 of the counter, they have given in the same counter, they have given here also. The employees who would like to continue in CPF scheme were, however, required to exercise a clear option to continue in CPF. It is pertinent to mention here that the service book of government employee, which is maintained under Government of India, supplementary rule is vital and primary documents. And all the important events and developments took place during the service of an employee is recorded in her service book based on documents. Evidence available is that the librarian prior to 86, when the board scheme that allotted CPF number, the document on which basis the entries had made in the service book may not be available on records due to passage of time, weeding out of records, etc. So my exercising of option to continue in CPF scheme was not there.
You retired in 2016.
16. And my lord, because of all this problem, my lord, that he chose to be in the group. That group, my lord, it was tribunal decided all that whatever your lordships has decided, affirming the tribunal's judgment, and not factually seen my case. I am different from that lot. I am not coming under that lot. I am a librarian, and throughout country I have been posted. and always in KV's my lord conduct rule, every application should go through the proper channel. There is no evidence on my case, my lord, that they have ever.
But kindly come to running page 27, internal page 2 of the order of the tribunal. Paragraph 5 of the order.
My lord.
Yeah. Come to that KVS versus Srimati Jaspal Kaur.
My lord.
Their observation of the apex court. Kindly read that.
Maybe it's para 5. On the other hand.
No, para 5. That it is. The para 5 of the count. Is it counter? Kindly come to counter. He only to the extent he has reproduced the observations of the apex.
That is where in the case, my lord, I have Jaspal Court judgment, where, my lord, there is a written consent, conscious decision to continue under CPF. Jaspal Court is that. And thereafter, Sasikaran judgment.
Do you have that judgment copy? You that copy?
I have also filed with the judgment copy, 2 copy, earlier already filed with memorandum. That Jaspal Court case already filed.
Right now you have.
Already Jaspal Court is referred already. The document I filed is, yes, change his nominee in 2008, my lord.
You have to do that. As for the.
This once option, once exercise, that is final.
Where is the option?
That is, he has.
No, she has not exercised.
Admitted. He has admitted he has exercised option. That is my case, and he has changed his nominee. That is my case. He has not shown his records.
Where is that show?
That is done. Kindly have a glance. He has exercised his option.
When exercise was made?
My lord, his representation running page 19.
Running page?
19 of read please. His representation. Dated 18.
Date, not year. Date means what?
3/10/2018. That is speedy post date because he has mentioned that date not readable. In speedy post readable 3/10/2018. That is speedy post receipt. Myself, Ajit Kumar Babu, joined KV 16/11/81 and retired on KV 19/2/2016 as librarian. I had opted that
for CPF.
Opted for CPF and had requested to KVS for change CPF to GPF beneficiary plan several times during my service period through proper channel. I had been facing with strong financial difficulty. That is.
This is after retirement.
That is, this is after retirement of 2 years. And next page, that is application page 20, my lord. You also got it?
No, there is one sentence, madam.
And here there is.
Exactly. I'll come, my lord. Your lordship, I know your lordship. I had opted for CPF in 81. When there is no option case comes, my lord, 88 was not there. That is the next page, my lord.
Where is the question of option in 1980?
That CPF.
That was the CPF was the only way.
Yes, exactly.
Then where is the option?
There is no option. They are saying that I have opted.
No, you have.
Kindly see.
After that.
My lord, that language is librarian. Annex
it's a librarian.
Page 20.
Kendriya Vidyalaya.
My lord, page 20, my lord, kindly see. My lord,
school.
Page 20, kindly see. Page 20. in the first year of service, 1981 year, I opted for contributory provident fund.
Correct.
Here, I opted, there was no option at 81. 81, that no option was to be given. That is the loose, my lord, that's nobody is that vocabulary, that is the poverty of vocabulary. Nobody has that strong vocabulary.
Not
No,
read three.
their option means they
Three.
thought.
Point 3, he has not read his point 3.
I was
allotted CPF number, old CPF number 442, which was subsequently changed. New CPF number 2199. Only he has given the subsequent form. Therefore, he has revised. He admitted he has revised.
Yes, that
and
is the
in
authority.
2008, I have filed in my counter. He changed his nominee in 2008 with the
CPM itself.
CPF continue with the nominee, change their nominee in 2008 with the signature of two teachers. I have filed in my counter. That is only one document I am showing. Please admit. Please,
What admit?
please allow me.
Let me
Page 42 of my counter.
Let me submit.
This is Form B. He has submitted.
I know I am against the way your lordship has passed the order, but this is not the way that my learned friend will say the strongest, holding the strongest order of this honorable court. And this honorable court has infinite wisdom and ocean of knowledge. And you don't that is the finality. My lord, kindly see. My lord, in that page 20, what I am saying, I did not file any and submit any option to opt to continue under contributory provident fund scheme in terms either to the department, pensioners, welfare, such and such. My point here is that what my learned friend is saying, they have given me when I was at Bihar, they have given me a letter in 2008 to change the nominee. They are under the impression that this CPF after retirement will become to GPF. That is not, because CPF, they are deducting 10%. In the GPF, they are deducting 6%. So he was under, but what is the requirement of the OM? That you must have a conscious decision that I want to continue under GPF.
We'll look into all the papers, then pass order. We can't just go by just arguments.
Your lordship, my lord.
Hard result.
My lord, one point my lordship, there is no delay in pension. That is a recurring cause of action. My lord, kindly.
Only you will see kindly.
That's true. There is no delay in pension.
But they have
modes of pension when you are choosing.
My lord.
Then there is
My lord, page 42 only
that I am not giving any judgment to that effect.
Page 42 of my counter, that is change of nominee. He has changed the nominee in 2008 with the signature.
That is the authority. That is the authority did it.
At the application, he is stating that I have never opted for CPF, but in the 2008, he has changed his nominee. Running page 42 of my counter, I have filed before the tribunal. That was verified and stated that you have already changed in 2008.
You have failed to submit that option report, option card. And that is the manner in the OM that has been decided, my lord.
Obliged.
My lord, that subsequent judgment,
we'll look into everything.
My lord, there is a subsequent judgment which is.
That is there. That has been followed.
I have already filed the written notes in time. Because you will be directed to file written notes in print.
All right, thank you.
Obliged. Yes.
But may I file the written note?
If you want to file, no.
But this is the subsequent judgment exactly.
That is also concerned.
That is, I have already handed over in that case. That case, I have already handed over.
My lord, paragraph 38, my lord. That I have marked it. This is the judgment that I have never filed any option, never given any option.
Just give.
But in 2008, I have changed my nominee.
That nominee does not mean that I am.
Yes, next.
Obliged.
Item 24, WPC 1346 of 2025.
Item 24. I am applying for open number 2 and 3 in first case and second case 2 and 4. 2 to 4, madam. Already counter is ready and it was sent for printing to the Delhi, madam. I am repeating panel council of ICA, madam.
When are you going?
2 weeks after IPA, madam, 2 weeks after.
My lord, 89 years old person. Second, third generation.
2 weeks, will he become 90?
The appropriate date kindly fix for
that week. 2 weeks, give some date. Call on. So at the request of.
My lord, in the second item, I am for the petitioner. I have filed one small amendment then.
What is that?
That actually incorporation in this very good.
IA is filed.
IA is filed.
IA to be heard along with the main matter.
Yes, already.
Yeah.
Item 25 notices have been adjourned. Item 27, WPC 288 2025.
Item 27. 26, my lord.
Item 27, I'm appealing to the opposite method. So they will restrict it towards the counter.
27, 2025 matter.
My lord.
After 3 weeks, at the request of learned counsel appearing for the OPs for filing of counter, when each right to file one stands forfeited and the petition amendments will be taken with face value. Next.
Item 28, WPC 29267 of 2027.
In this case, I am appealing for OP number 203. Lordship grants some time to file counter.
Here, my lord, cat order has been challenged.
Yeah.
The counter already I have annexed, which they have filed in the before the central administrative tribunal.
So for the repression, I will file counter.
He wants to file counter.
Yes.
You file. You have filed counter before the CAT.
Yes, madam.
But what counter you will file?
Now, they
227.
have taken all other grounds also.
Whatever
They
counts you have filed.
challenge that order. So I have to meet my lord. The department has given the instruction.
No, you might have given. Where is the right to file counter here? It's a 227.
The read petition, yes.
Because against the order of the tribunal, all pleadings of the tribunal will be before this court.
But to challenge the order, that is.
If you want, we'll give time, but not for this.
Yes.
My lord, a retired person, your lordship.
Yes.
Is a retired person, my lord, recovery has been done.
How much money recovered?
6 lakhs some odd, my lord.
Wait. Which category employee?
My lord, is a bank officer, my lord.
Not Group CD.
He has deputed to.
Otherwise, we would have said Rafiq Masi, etc.
Yes.
That will not come.
No, my lord, that or Rafiq Masi, within the period of 1 year of retirement.
No, that is Rafiq Masi is in respect of Group CD.
No, central government has issued a resolution, office memorandum, applicably universally to all officers, my lord. And those who are retiring within 1 year, no recovery shall be made. So far as the Group C, Group D is concerned, my lord, that is point number 1. This is the 2. The persons, those who are going to retire within period of 2 years, 1 year, no recovery shall be made.
Let us. Any judgment on that?
Office memorandum is there.
No, we are asking. Is there
the Rafiq Masi itself says, my lord?
No, Rafiq Masi is not on.
Yes, my lord. I have brought the Rafiq
Masi. Just Kehar's judgment.
I brought, my lord, that judgment.
No, we have referred to it in half a dozen judgments already. Let us see.
1 year retirement or no recovery.
Let us see. Yes. Next.
Item 29, WPC 31416 of 2025.
The petitioner is a ARC, my lord. Is turned into a secure creditor. It applied for an assistance under section 14 of the Service Act. That has been turned down by the London CJM.
On what ground?
On the one ground that there was huge delay between 13.2 and the exercise of the 13.4.
Can it be a ground?
Not only that, Your Honor, I want to mention the facts on which Honorable CJM denied to grant him the order. First point is the 13.2 notice has been issued after 15 months of the NP of the account. First thing. Second thing, the 13.4 has been issued after 8 years of the issuance of 13.2. Third one is the issuance of 13.2 and the serve of 13.2 has not been established before the Honorable CJM. And the fourth is the ARC.
You undertake fresh exercise will permit you. Instead of doing all this, what we suggest is, you take all fresh steps.
Within 45 days, as per the stipulation in the Act, my lord, let that application be disposed of. Because that has to be decided within 45 days. If I file the fresh one.
No. There is a finding that 13.2, 13.4, these things are not issued at all.
No, my lord. It is issued. Let's say a glance to page. They have admitted in their surface application, my lord. They have received it. Let's say a glance to page 65 of my brief, para 5.16. that the respondent has issued a notice under section 13(2) of the Act on dated 5/15/2013, whereas the loan account has been identified as non-performing asset. That means they have received it. And after
No,
receiving-
Your Honor, we are not receiving.
Allow me to-
Your letter, whose letter it is?
It is the surface application. They have challenged my possession notice before the DRT.
Yes,
This is their version.
Their application.
we mentioned the fact. We mentioned the fact the 13(2) notice has been issued on this particular date. Nowhere it has been mentioned that we have received that particular 13(2) notice personally.
Your client appears to be the truth.
And that notice they have annexed, my lord. Annexure 6 is the
cost.
Annexure 6, they have annexed that notice, 13(2) notice before the DRT, after receiving it.
Therefore, you know that argument also is not available to you. On what ground the tribunal has
Tribunal dismissed it for non-prosecution. They did not participate in the hearing. Alert they say were dismissed.
No, that was their objection to section 14 application.
Well,
Their objection to section 14 application of yours. Who was before the CJM?
I am before.
You are before the CJM as bank.
There is a bank.
They have filed objection.
Section 14.
That's what we are telling now.
Section.
Did they file objection to?
No.
But these facts you say they have brought before the DRT.
They brought before the DRT in the essay.
In essay.
In a section student application.
Or in your own application.
That is, they have admitted of received every communication before possession.
Why the CJM says like that?
My lord, CJM said that it 25/4/2025, where the essay was given in 2021. The securitization application was filed in 2021 before the DRT.
We will remit the matter to the CJM instead of we passing the order. We will remit the matter to the CJM for consideration afresh, where
Yes.
all contentions we can take up. All right.
Oblige, Your Honor.
Both, right. This petition by the lending agency calls in question order dated. Where is the order?
Annexure
27,
84, page 84, annexure 6.
24, 25 for 2025,
27.
whereby it's applicable, whereby miscellaneous case number 151 of 2024 filed under section 14 of the Surface Act 2002 has been negative. Next paragraph. After service of notice, the OP, one OP, how many OPs? OPs have entered appearance
6 OP.
through that. Or you appear for all the 6?
No, Your Honor. Not for all.
You appear for whom?
I appear for
Contesting OPs, my lord.
OP number 2, OP number 3, OP number 4, OP number 5.
That's something. 2, 3, 4, 5.
2, 3, 4, 5.
One is not required.
One is not required.
Not required. Then 6 is a mortgagor or guarantor.
My lord.
Whether notice went to him. Whether notice was sent to OP6.
Yes, Kamalakant Swami, my lord, notice was sent to all notices.
Not represented.
Kamalakant Swami appear kon?
Panaklata Swami. I am Panaklata Swami. OP5.
OP5.
Yes.
There is one. Then all are represented.
Yes.
The answering OPs have entered appearance through their counsel, who initially resisted the petition, contending in support of the reasoning of the court below, as has been reflected in the impugned order. First time. Next paragraph. Both the sides, after advancing their respective arguments, have graciously agreed that there are some lacuna in the impugned order, and therefore
the same be set aside and matter be remitted to the portals of the CJM for consideration afresh, keeping open all contentions of the parties. First off. This time is just and reasonable. First, next, in the above circumstances, petition having been allowed the writ of certiorari issues, quashing the impugned order, and matter is remitted to the portals of learned CJM Hurda for fresh consideration of miscellaneous case number 151 of 2024 within an outer limit of 8 weeks. 8 weeks. First of all contentions of the parties are kept over. No cost.
Item 30, WPC 36157 of 2025.
Yes.
I'm for the opposite party number.
What? Lending agents.
No, sir, I am appearing for 1 and 2.
Because the person.
But I am for the petitioner.
He wants to file counter, let him file. Call this matter after 3 weeks to enable.
My lord, let the matter be fixed, my lord. My case fair, my lord, I am coming from Kolkata, and if the matter doesn't.
Which date you want?
My lord, 10th April.
10th April. Instead of 10th, you take 15th.
In the month of
15th,
maybe. My lord.
Call on 15th April at the request of the panel counsel appearing for the lending agency.
No, I am on the auction purchaser.
Auction purchase. That is opinion.
I am appearing for 1 and 2 months.
Yes. Next.
Item 31, WPC 3034 of 2026.
Item 31, the Lordship pleased to issue notice on the 5th of February 2025 minutes. The noting says to the addressee
not delivered.
Absent for so far as OP 6 and 7 is concerned. My limited prayer would be subject to your Lordship's kind consideration. May I be permitted to take notice on 6 and 7 by special messenger?
Fresh notice through special messenger to be taken by the petitioner.
On 6 and 7.
On OP number 6 and 7.
And 5, now the AD is back, so far as the bank is concerned. The noting says 5.
You take to bank also.
No, AD is already back.
AD is back, but nobody is representing it. Therefore, take notice, fresh note on all OPs.
Since all the 3 are in Sundargarh, may I pay for one set of process? One.
No, that will be
unless your Lordship orders, they will be sending 3 messengers. So because all the 3 are in Sundargarh.
There can be one single messenger. Since all the OPs are from the same place.
Sorry.
There can be one messenger. Since all the OPs are from the same place.
Same place, that's Sundargarh.
That is Sundargarh. Steps to be taken immediately. Okay.
Within 2 days, I think.
Call immediately after service.
Item 32, WPC 3997 of 2026.
To last occasion, my lord directed out to obtain instruction in respect to the page 75 document. Orally, they have given any instruction. I want to file an affidavit. Very quick.
When will you file affidavit?
By next week.
26 matter. Call up at the request of the DSTI body. Yes.
Item 33, Case Appeal 202 of 2020.
Let them supply a copy to me.
Yes. After affidavit, I will supply.
You give that.
Item 33.
Lordship, it will be listed on the next week.
No, after 2 weeks. 2 Next week, we have some date.
It will take 2 minutes only.
All cases will take 2 minutes only.
Let's see, I know listing has become very difficult. This matter also 3 occasions left.
No,
So-
but we have been taking, once it comes to our notice, we have been taking. No, when we say 2 weeks, it will come immediately after 2 weeks. Otherwise, we move a memo.
No, not necessarily. It will come in the supplemental list.
If it does not come, you.
It is coming here, Lordship.
Yes.
Item 33.
My lord, reflection of a contractual employment.
Covered by judgment.
So, in this case, my lord, I lorded say, AGA, my lord, Mr. Ponda is appearing, my lord. So we kindly pass it over.
What purpose of this? Covered by the judgment, na? Will it come? How many days of delay?
Delay, my lord, 307 days.
370. No, it's nothing.
Time होने में वो बताने को time नहीं
370. In all 370 days.
बाकी होने वाला
The subject matter of these appeals is substantially similar to the one in writ appeal number 1381 of 2025 between State of Odisha and others versus Tapan Kumar Sahu, disposed of by us while order dated 17 February 2026. First one. It is an order both on merits and on delay. First one. The above is the order rendered both on merits and on delay application. First one. Delay was 217 days in filing that writ appeal, and an application was filed seeking its condonation. The said application was favored after being convinced of plausible explanation. First one. Here too, we have to take the same view. Since explanation offered is prima facie acceptable, there being sufficient cause for the delay proved. First one. Therefore, condonation of delay is accorded. First one. Next one. In the above circumstances, these appeals fail. These appeals fail on merits. First one. The impugned orders of the learned single judge. The impugned order of the learned single judge shall be given effect to within an outer limit of 8 weeks, as has been prescribed in the cognate case, and a compliance report be filed before the Registrar General of this court within 1 week next to following, failing without giving scope for contempt action. No course. There are how many matters? There are 5 matters. 5. Yes. Next.
Item 34. Writ appeal 1449 of 2024.
Yes, sir, and for the respondent. Last week also appellant
Did not turn up. None appears for the. This is 30? 34. None appears for the appellant. First, to enable counsel for the appellant to come and argue, call this matter after 3 weeks. Okay.
Item 35, Page Appeal 1894 of 2024.
Right. 35 million. State appeal Mr. Ponda is appearing.
Covered matter yesterday it was there. On being mentioned, it was directed to be taken today.
Sure.
Married daughter, your lordship husband.
Married daughter, Apex Court has said, na?
Yes, your lordship also
affirming, we have also taken the view because of Justice Nagpatana's judgment.
Yes, yes.
Karnataka High Court.
Yes, yes.
We have referred to that judgment.
Yes, I have enclosed my affidavit. Flag D, your flag D.
That is affirmed by the Apex Court.
Your lordship husband.
No, not this judgment. The judgment of Justice Nagpatana.
Yes, yes.
Is affirmed by the Apex Court.
Yes. That is also reflected in our High Court judgment.
In my judgment also, in our judgment also I have mentioned.
Yes. That is
read that paragraph. We remember, we have taken up, we have mentioned the name of the judge himself.
Yes. Yes, in para 6.5. In Keswananda Bharati case, that name. Okay, para 6.6. In relevant to mention that M. Nagaprasana just in so case versus Karnataka observed, he also quoted the provision. Now, thereafter, the above view received by the acceptance by the Apex Court in the case of State of Karnataka versus
Apex Court
and you also quoted that
implemented on that judgment.
I am enclosing my affidavit. I am also giving and on is only directed to consider. That is the impugning order. Not directed to give appointment.
Only for consideration.
Yes, that is the impugning order. Also kindly see.
On consideration order, sir, what unless the consideration scope is
page 36.
Panda has come now.
Yes.
If Panda comes, then what he will say? Let us see.
34 item.
35. Daughter's right to
My lord.
covered by the judgment.
Lordship have let down the law entitlement, but so far as the
sit down.
My lord.
Take this matter for 5 minutes.
No,
can be disputed.
Yes. No, I can. The new rule may be invoked because, my lord, all the pending matters are covered by the new amended rules.
That is 4.25.
Yeah, 4.25.
Yes, that is one way.
Yes.
State and its officials are calling in this intra-court appeal. State and its officials are calling in question. State learned single judges. Single judges.
Yes. Order dated 9/1/2024.
Dated 9/1/2024, whereby respondent employees WPC number 127 of 2024 having been favored, following relief has been accorded to her. Relief also just in para 6. Next paragraph. After service of notice, the respondent employee elected appearance to her counsel, who places on record a copy of this bench decision in
WPC number
WPC number
32107 of 2011.
That Macha.
Yes. Money Macha.
Between
that is Money Macha versus State of Odisha. Available at page 54 of my affidavit.
Is poured off on
3/2/2026.
3/2/2026, which has answered the question raised in this appeal as appeal after referring to a plethora of rulings. First one. Therefore, we need not undertake a deeper examination of the same.
Only one prayer.
Matchable from all fours
We may be given liberty to examine the case and if
That
fit
is
in.
given now.
Consider,
The learned single judge himself.
Yes, yes.
First, this apart, the next one, the above apart, there is above apart. The learned single judge has directed consideration of the case of the respondent for compassionate appointment.
in the light of the
in the light of Hirabdi Bala.
Hirabdi Bala Behra case and Basanti Naik's case, along with your lordship's
judgment.
Money Macha case and the amended rules.
No. Hirabdi Bala versus State of Odisha. In any report is there?
Yes, that Hirabdi Bala is reported.
WCC 1.
Yes, that report.
The report, law report is there.
The law report, it is reported, but I have enclosed only the website copy.
In WPC number
945
2015. Disposed of on
24/8/2022.
2022. And another companion case, namely Vasanti Naik versus State of Odisha in WPC OAC number 2669 of 2008, decided on 27/10/2022. First one.
In Hirabdi Bala, the rule has been struck down. That very provision unmarried.
We are told at the bar that in Hirabdi Bala Supra,
yes,
the rule itself has been struck down. First one. Mr. Panda learned AGA tells us that new rule has been promulgated.
With effect from 4/4/25.
With effect from 4/4/2025. And the consideration and liberty should be reserved to the appellants to consider case of the respondent employee in the new regime. First, counsel for the respondent is very fairly agreeable with this proposal. First, in the above circumstances, this appeal is disposed of with the above observations.
Grateful, my lord. One prayer, my lord. I may be pardoned for
the order of this to be
3 months, my lord.
Implemented within an outer limit of 3 months, without giving occasion for taking contempt action.
If
taken, would result into levy of heavy costs.
But so far as the
payable personally,
my lord, this is the my lord, some cumbersome process is there.
3 months.
If needed, we may seek for more time.
We do not know. You apply, we will see.
Yes.
Reject it.
Grateful. My lord, I'm being pardoned for that. I was not present.
Covered
30th, not that is not covered, my lord. That is our case.
Yeah, sure.
33.
No, 33.
33 is a project case, my lord. It's a project employee.
Matter we have said that.
That Dandakaranya case will come into play, my lord.
No.
If the project is not subsisting.
We don't agree with that because there may be similar projects which you have to consider.
If that employee, that petitioner is still continuing, then the law will be different.
You have taken up the contention in the writ appeal that this judgment is not covered by that.
But we have distinguished that Patita Pavan Datta Rai case, my lord.
No, but we have this argument is considered in that writ appeal. In our writ appeal, even this argument is taken care of.
My lord, on single judge has relied upon Patita Pavan Datta Rai. Patita Pavan Datta Rai data entry operators are placed in Tahsil office, which are regular establishment.
Correct.
But this is a project establishment.
But we have held, even in such matters, you are to do the exercise. Anyway, we have passed at heart. Yes, next. Very many people will be seeing. We cannot meddle with our orders.
Because
next.
Lordship,
but I have condoned the delay in that.
And we have 1 week time to seek instruction because whether the project is still subserving or not.
Nothing like that. Next.
Item 36, Writ Appeal 1785 of 2025.
36.
This writ appeal, my lord, arises against an order of the Lord Single Judge
a proceeding under the Orissa Cooperative Societies Act.
Cooperative Societies Act. Of which year it
The
is?
fact of the case is that.
Act is of which year?
Fact of the year,
No,
my lord.
Act of.
Act. 62. 1962.
Any rules are there?
Yes.
Of which rules?
Cooperative rules, my lord.
No, tell that.
The Odisha Cooperative Society Rules 1965.
16. Hmm? 56. 56.
Act is 62
Rules is 62.
and rules is 1965.
Yeah.
First, I will submit before your lordship the facts.
You drag that mic near so that you become more audible to us. Mic.
The appellant before your lordship has supplied groundnut to Oil Odisha.
Oil Odisha. Oil Odisha means what? A company.
No, Oil Odisha is a government.
Odisha. Government undertaking it.
Yes.
Not in dispute. Anybody disputes this version, first sentence? Is it an entity under Article 12 or not?
Yes.
An entity under Article 12? Not.
May not, my lord.
May not.
Because Oil Odisha is a cooperative society and the present appellant is also a cooperative society.
Whether that comes under Article 12 or not.
Oil Odisha is strictly it is not coming. Strictly it is not coming under Article 12.
How it is managed? Who are the office bearers of that?
Well, Joint Secretary Agriculture.
Then it is Bhagat Singh.
Now it is under liquidation. So
No, may.
That's all right.
May.
now
Must place the facts.
No, what sentence we want to assert?
Yes, ma'am.
Truth or not?
Yes.
my lord, this
We
is
have to present that.
which has not been admitted so far.
Huh?
Decision writ appeals both not admitted so far.
Admit
For admission, I am.
issued or not?
No, my lord, it is a fresh matter. That's why, my lord, I have prayed before your lordship to bring it under the.
All right. Fresh matter.
Press matter.
I thought since they were appearing already noticed.
No,
They have appeared for motor.
They have gone there.
My lord.
All right.
My lord.
Who can prevent them appearing? With
My
an
lord.
open court.
Yes, ma'am. My lord, supplied groundnut to the Oil Odisha.
When it was?
My lord, it was in 2002.
You have not brought groundnut today.
No. Our society is closed because of non-payment of the dues.
Non-payment of the
Groundnut seed.
arrears supply.
To Oil Odisha.
Seeds.
Seeds. 2002.
Not oil seeds. It is for sowing.
No. Seeds will, from where the oil will be.
That is oil seeds.
Oil seeds.
Seeds.
Oil seeds.
Because they have not paid the dues which you have supplied, we raised a dispute.
Under which section?
Under section 68.
68.
My lord.
That is a statutory arbitration.
Yes.
ARCS.
Yes.
There is.
Yes. And it was referred to the arbitrator under section 70. The award was passed under section 70. 70.
Reference is under 68.
68.
What is 69?
Limitation.
Limitation. Okay. 70 is arbitration. It is a statutory arbitration. Some statutory officer will do.
Yes.
Like Karnataka Act also, we have similar statute. Even sections are a little different, 69 and 70. But
here is 68 and 70.
Okay.
It was referred to the, my lord, under section 70, and award was passed in favor of the appellant. That was passed
on
31/10/2008.
Yeah. For a sum of
rupees 2 crore. That is 2 crore
Plus.
with 2 crore 12 lakhs 60,000 so on. With an interest of 12%.
Yeah.
And they have been directed to pay within 3 months.
3 months. Yes.
Since they have failed to pay, the appellant liable execution under section 103 of the Act.
Separate execution proceeding is there.
Yes.
How is it like provisions of Order 21 of CPC or anything different?
No, nothing different. Order
Same.
21.
Identical. Execution is what mode? Mode of execution. There are 5 modes of execution.
Execution, my lord.
Which mode you had chosen?
I have chosen to pay the money.
No. Which mode you do have?
Arrested detention, attachment of property.
Attachment, I filed the execution so
Then
that
you enforce this award.
enforce this. My lord. In the execution, my lord, since they have not paid the amount, the properties of Oil Odisha was put to auction.
Was ordered to be put to auction or put to auction?
Was put to auction.
Put to auction. Auction took place.
Auction took place and
Yes.
I am the successful bidder.
Auction was held on?
Auction only my lord final order ta
Execution case number?
that is EP number 34 of 2009-10.
When order to auction the property was passed?
Sita 13th April 2011.
Then what happened?
I became the highest bidder, my lord. Therefore, the sale deed was executed.
On which date sale deed was granted?
Certificate was issued.
Sale certificate was
issued on 16/11/2012.
Whether that sale certificate is compulsorily registrable or not?
It is not registered.
Not.
Well, thereafter also, they remain in possession. Oil Odisha remain in possession.
Sale certificate was issued, but possession was not given to you.
And it is impossible on the part of the appellant to take over possession of the property of Oil Odisha. While the matter stood thus, my lord, the Chief Secretary has called the petitioner for a conciliation in 2016. In the conciliation, my lord, the register was in one for the government and we are for the
private.
In the conciliation, they have only agreed to pay the principal amount, not the interest.
And you agreed to that?
No.
You did not.
Then
you should say they agreed. No. They proposed to pay.
Yes. Then, my lord, in 2016, that conciliation was taken place and it was failed.
If failure report is dated?
Your lordship will hear?
Anyway, go further. Let us see. Now, the cooperative, that's also cooperative society. You are also cooperative society.
Yes.
You are a private cooperative society.
Yes.
They are
government-owned cooperative society.
Governmental cooperative society, because society company, they cannot be owned. Anyway, okay, understood. Then,
my lord, since neither I could get the possession of the land, nor, my lord, I am able to get the money for which I have filed the writ application here.
That is rejected on what ground?
That was not rejected. Kindly bear with me, ma'am.
In the writ petition, there was a direction to place before the conciliation permanent local adalat. High Court local adalat. High Court local. There also the conciliation failed. During pendency of the writ petition, since they were proposed to give the principal amount, this court interfered. You pay what you have proposed, you pay. So they have paid part payment 1,56 lakhs or some amount. Then, my lord, they have issued a letter to the government, Oil Odisha, to pay the rest of the amount. That is, my lord, admitted amount. They have agreed for the principal amount, my lord. And finally, this matter was listed for hearing. In the hearing, the Oil Odisha also challenged the sale in a different writ petition. Both the writs were taken. None of the parties have prayed that there is an appeal provision. They will approach the appeal. The court so moto took up that thing after 17 years of the hour and after 13 years of the execution, condoned the delay and directed the Oil Odisha to file an appeal. They will file an appeal, delay of so many days will be condoned, it will be heard on merit. The amount which they have paid, if they will succeed in the appeal, I will return to them. That is the limited grievance of your lordship. Whether the court.
The direct filing of a.
And condone the delay. Delay will be condoned.
It is for the authority to condone the delay, not for the writ court to do it. But if it is rejected, then writ court can do. The powers of the writ court, whether it is 226 or 227, is coextensive with the powers of the authority whose proceedings are brought for judicial review. But this is a bit different case.
Well,
your first contention is court cannot direct filing of the appeal. Then court cannot say delay is condoned. Although in some cases it can say the limitation shall begin from such and such date. Sometimes we say that also.
That is the only prayer before lordship. Nothing has been done. After so much of my lord exercise, I have got 1,56 lakhs.
No, even
they are also agreed to pay the rest amount at this juncture.
Where is the proposal of the government to pay the principal amount?
That is, my lord, at page.
Have they filed appeal accordingly before the tribunal? There is any tribunal? Appellate tribunal you have?
Yes.
Orissa appellate.
Yes, it is filed within the time directed.
As directed.
As directed.
Where is that order which directs filing of appeal?
That is the order impugned here.
No, read that. Text of the order. Operative portion of
That is at page 62, paragraph 8(1). Paragraph 8 and 8(1).
When the award was passed in 2008, but writ petition was filed in 2012.
2012, they have challenged the.
No, we want to know
again
when the writ petition was filed.
They have. My writ petition was filed in 2022.
No, their writ petition.
2012.
11050 of 2012.
Challenging the auction.
Challenging the auction.
Auction sale.
Award was not challenged.
No.
Where is that? They had laid a challenge to the auction. Where is that?
Well,
That only,
to show
yes, madam.
that their prayer, have you made part of the record, their pleadings? Then how writ appeal is maintainable? Unless writ appeal is continuation of the original proceeding. Therefore,
Madam, there are two appeals. In my appeal, I have not filed because I have only come for my lord that amount may be paid to me. The appeal which was the repetition which was disposed of 2012 writ application, another appeal is filed.
I have filed another appeal. I was appearing for the society. The appellant here who was the opposite party before the learned single judge for the society, and I filed that
opponent of madam.
No, I am not opponent of madam.
Your madam client also is your client.
Yes, yes.
In appeal number?
In appeal number 1912.
Posted today?
Yes,
my
yes.
lord, it is tagged. Both the appeals are tagged.
You have challenged what?
I have challenged
Same
an
order.
order that
Same order.
after the amount has been paid, after the decree has been accepted partly, and amount has been, and the execution of the amount has been paid.
No appeal lies. No
Whether any appeal will lie or not, and that too, can the delay be condoned after 17 years of the award?
No, it all depends upon the question is how long the delay is irrelevant once notice is not served. There are many such circumstances.
Yes, my lord.
But question is, it was a 2012 writ petition.
And 2012 writ petition was filed after the entire process was over and the order was examined. The execution case record was called for by another division bench of this honorable court. The matter was examined. All the officers concerned and parties concerned were directed to appear personally. The record was examined, and thereafter the order was passed for issue of sale certificate by this honorable court. Thereafter the writ petition was filed with a plea that we have never issued with any notice at any stage, which is absolutely false. That 11,050 writ application, that the writ petition arising out of which this writ appeal arising, that writ application, they took a stand that at no stage we have not been informed, therefore all the orders are illegal.
In the award, they did not.
They contested and the award was passed on contest. That is in the annexure 1 of my writ appeal.
It was passed after contest.
On contest. Both sides appeared. In execution proceeding,
contest means objections were filed to the
yes, my lord.
Claim petition.
Yes, my lord.
What you call in your state under 6870, where petition is filed, what you call it as?
It was raised under section 68 of the Orissa Cooperative Societies Act for recovery of the sum. They filed the objection and that was disposed of and the award was passed under section 70.
Where any party witnesses were examined?
Oh, yes, please.
Witnesses were examined from both the sides.
Record for examination. Records were examined. Because it was the admitted case of the there before the court below, where the forum below, it was the admitted case. Yes, the society, the present appellant society has supplied. But because government has not released the money, therefore at present we are unable to pay that amount or disburse that amount to the society. That was their stand before the original forum.
They admitted their liability.
Yes, my lord. Admitted the supply, admitted the liability, but they say that because the state government did not release the money, therefore we are unable at this stage to release that, to pay that, disburse that money to the
state
supply.
It was not a party.
State government was not.
Whether that society is still in existence or is ordered to be wound up.
During pendency of these litigations, this order was passed for liquidation, but it is still the liquidation process is going on.
Going on.
Yes.
But once liquidation begins, whether who appears for the society, then liquidator has to appear for the society.
So liquidator is appearing.
You are for liquidator,
sir.
We have implemented liquidation.
He has been implemented.
How you could take a contention that no notice was issued to you when you had notice was issued, you contested the proceedings, you examined the witnesses on your behalf.
No witness was examined, only documents were produced.
Documents were produced.
Witnesses were not examined.
Very well. How can you take up without notice it has been done? You have filed your objections and you have filed your documents.
Yes. I am coming to that, that is part of the record also. The basic prayer in the read petition was, my lord, to set aside the order of the joint register, the dispute order.
Auction order.
No.
Award, initial.
Original order, 2007-8 order. In the dispute
Award.
order. Award, rather.
Award, you say award.
Award.
It is not order.
Awards. And
That is 31/10/2008.
my lord. And subsequently, other efforts pursuant to the other auctions, actions. There a counter affidavit, there was a reply was filed by the society, my lord.
By your society.
Your lordship may kindly look at, that is annexure 1, dispute.
Yeah, 1 second. Your 2012 writ petition, what you had challenged in that?
I'm placing that, my lord.
Because madam said that the challenge was to the order in execution.
No. That was not the
It was challenge was to the award itself.
Why the order of the joint registered cooperative society had annexure 5 shall not be quashed. That is the award.
Date it, you tell me.
Annexure 5.
2008.
No, page.
26.
And 26 of the read petition. That is, they have given a nomenclature as judgment.
By the joint register.
Act 31/10/2008.
Then it's award only.
But
Award
nomenclature is judgment.
whatever they may call
Yes.
it, it's an award.
So this was challenged. The primary was, my lord, why the order of the joint registered cooperative society had annexure 5 shall not be quashed. Second, as to why the order of attachment and sale of assets of Orissa Cooperative
All
Society.
right, what were the grounds you have taken in that? For quashment of, there was a statutory appeal.
My lord.
Appeal is provided under
That
section
is-
109.
That is there in the judgment itself, in the award itself. My objections are there reflected in the award itself. Should I place few paragraphs, my lord? My basic objection before the joint register was, number one, here agreement has been entered between the parties where it was agreed that 90% of the cost will, after realization from the farmers, will be paid to you. Rest 10% is dependent on receipt of subsidy from the state government. Hence, state government is a necessary party. That I had stated in my reply. Second, my lord, I had stated.
How state government becomes necessary? It's a privity of contract. When she sells her goods to you, it's a privity of contract.
Yes, but that is there incorporated in the agreement itself.
Saying that is payment.
Your lordship may bear with me.
Payment 10% payment will be paid by the government. You will be paid 10% when the government sanctions that.
Yes.
That will not make the privity of contract.
We don't have money of our own.
Correct. But that cannot be a ground at all.
That is part of the agreement. Whatsoever, howsoever your lordship looks at it. The defendant specifically relied on clause 13 of the agreement to combat the plaintiff's claim. It is contained that the defendants that the material supplied by the plaintiff have been sold to the different farmers at subsidized rates, and the shortfall subsidy has to be reimbursed by the government. It is contended that neither the farmers have paid the full consideration money nor the government has sanctioned the subsidy, for which the defendant is not liable for the plaintiff's claim. Payment, if any, is to be made by the government, for which government is a necessary party.
Where is that agreement between you and this one? Show us the agreement. You will supply goods.
I will place on.
Give it to the farmers.
I will place on record.
If farmers do not pay back, we will not pay back to you. That may not be the agreement. The sale of goods concept is bit different under the sale of goods.
No, we wanted there to make state government a party, because in spite of
how can you
without
whether state government is a signatory to your agreement to purchase that?
No.
Then how can
no, that apart I don't know. Then there was an agreement, there is a clause, arbitration clause.
That they have gone for arbitration.
No, that is not under that.
All right.
There-
Under which arbitration is under which?
Clause 23.
Did you take up that contention before the joint?
Yes. Number one, I said that state government is not a party because 10% has been retained by them so far. And second was, any dispute or differences arising out of this agreement between the two parties shall be settled under Indian Arbitration Act 1940 by a sole arbitrator to be nominated with the managing director of the such and such, and the decision of said arbitrator binding on the. I had filed a petition under Section 8 of the Arbitration and Conciliation Act. That came to be rejected. Will your lordship hearing it finally?
Then what we are doing now?
Then I have to come back better prepared, my lord, with all materials.
The latest judgment also come in your way, because an officer to be nominated by you to be the arbitrator.
12.5. That is 12.5. That section 12. I am conscious of that. So that it loses, so High Court would have appointed. That is another matter, my lord. Even with that conditions in the agreement, High Court is appointing. There is no bar to that. So that came to be rejected.
Now, how section reads? Let us see.
Which one, my lord?
How section dispute between society and society. How the section 70, 68, 70, how it writes? Let us.
May I please, may I read my?
Dispute which may be referred to arbitration.
Notwithstanding anything contained in any other law for the time being in force, any dispute touching the constitution, management or the business of a society, other than a dispute required to be referred to the tribunal and a dispute required to be adjudicated under the Industrial Disputes Act 1947, and a dispute relating to non-payment of contribution to the cooperative education fund referred to in subsection 3 of section 56 shall be referred to the register if the parties thereto are among the following, namely.
Now, where is the disputes between two society?
Yes, my
not contemplated here.
Yes, I'm coming to the ABC, I'm coming to that. The society, its committee, the past committee, any past or present officer.
That will not apply to you.
Yes, my lord.
Go to the next.
Any other society. Here, my lord, the explanation.
Dispute
society or by a society.
Sir.
Yes, my lord. I have to the explanation one. A claim in respect of any sum payable to or by a society, by or to a person or society mentioned in clauses A to D shall be a dispute touching the business of the society within the meaning of this section. That is explanation 1 attached to section 68.
A claim in respect of any same payable to or by a society, by or to a person or society, as between from one society to another, mentioned in clauses A to D.
How this explanation is interpreted by various judges of this court in the last about 40, 50, almost more than 60 years. This explanation is in the original text itself.
Yes, fine.
How various judges of this court have interpreted.
There is a claim. If it is a dispute, I will show a circular because I have not brought it. That circular of the Register of Cooperative Society, that if delegation of power, that if a dispute is between a society and a society, if the dispute between two societies, then the register is the authority. Otherwise, if it is a dispute within the jurisdiction of the deputy registrar, then only deputy registrar and the individual, the dispute between an individual and a society by the deputy registrar.
Deputy registrar cannot say what's the meaning of this section.
No, I'm saying the power has been delegated to the power of the registrar has been delegated to the different subordinate officers. The deputy registrar, joint registrar, all these things. There is under section 3 of this act, a notification has been issued by the state government that who are the authorities to decide a dispute. There is a clarification. I have not brought with that notification. But if a dispute is between two societies, then the dispute shall be referred to the register.
That's what notification says.
What notification says?
No,
That
that's
is
not the
19, if I remember correctly, it is 1982 notification,
That's
which
not
is
right.
still prevailing.
Very well. You can bank upon your memory. We have no objection. But point is, how this explanation is interpreted by various judges of this court in the last more than 60 years.
I'll find out, my lord, the judgment, but this is the position on the.
It appears to be that way,
Yes,
prima facie. But suppose if already courts have construed, answered this question, we need not go on reinventing the wheel.
Yes.
Whether dispute between two societies is within the explanation or not. That's the only question, first question.
Yes.
If that is so, then we travel to subsection 1, which you have to answer. See that. Notwithstanding clause is there. Section 68(1).
Yes, sir.
Which is the Henry VIII clause, which English people called as notwithstanding anything contrary to any law, whether that concept would include Arbitration Act also.
Yes, ma'am.
That you have to say now. Because by that time, arbitration 1995-96 Act of 95 Act had already come into force.
96.
96.
40 Act was there also.
Therefore, whether that excludes
the scope of arbitration. Arbitration Act.
Arbitration Act. Because the arbitration clause, which you have incorporated in your agreement, according to you, which you have not produced copy of the agreement for our perusal, that says the dispute shall be resolved by arbitration at the hands of an officer to be nominated by your client. That part also is now, it goes because of the
That is
petition.
gone. The 12(5) takes care of it.
If that is so, you will travel to section 11.
Yes.
Of that 96 Act.
11(6). Yes.
Whether that is excluded because of the non-obstante clause.
Yes, ma'am.
That you have to examine. Just look into that. Some serious.
And the decisions of this honorable court, if any available.
Number 1. Number 2, having remitted the money, can you challenge that award?
Money remittance is recent. After we got the money from the state
Because
government.
of execution and other things you have.
My lord?
Because of execution and other things.
No,
paid.
no, we paid it in the High Court. We received some money, 1,54 lakhs from the state government, part release. That money we transferred to them.
That means you acquiesced in the award.
Court,
you agreed with the award.
Court's intervention, my lord. Court said this is the money you collected, you pay it to them.
And you have paid that.
My lord?
You have paid that.
We have passed on. Paid means we have passed on that money to them.
Passed on means was it brought to the court in the suitcase?
No. Left hand, right hand we received, left hand we passed.
Paid by check only.
Yes.
Yes. So that money, whatever we received, we have parted with that. So we have not kept anything. Now, that being so, and the very fact that we are under liquidation, I don't know where we stand. Anyway, my lord, I'll come back with the legal aspects your lordship has raised.
No, your contention that without notice, the award has been passed. That is a militant.
No, award, if I have stated somewhere that award has been passed, if I have stated that is wrong, maybe regarding, might have stated that regarding, my lord, this attachment, sale and other things.
They are also received notice, I have filed a document, I have annexed the document.
In that they have taken up.
Yes, my lord, annexed to 3, my lord.
The problem is by that time it has already gone into dogs, that society. Our issue.
We have heard only cat.
No, not dogs.
Dogs we are yet to come back. Cat orders we have been examined.
So my lord, that was
examining.
So whether receipt or not also, I don't know. Anyway, those things I'll find out.
My lord, that apart, my lord, the maintainability of the writ appeal. Intra-court appeal. That
Because
is
of
correct.
full bench judgment.
Yes.
That is also there, my lord.
State government.
You have to answer that. Because we have held in other matters. So that Mr. said, the three-judge bench has said writ appeal is not maintainable if the order is under 227. And you are mentioning 226 is irrelevant for us. Just look into that.
My rate is under 256.
That makes no sense because
No,
we
no,
have
no.
said in our order.
The court has not put here against any of the order passed by the officers, the arbitrator, anything. There is no order was challenged before this court. The only thing that a prayer is made that direction be issued to them, since I am unable to take the possession of the direction may be made to them to pay the amount. Therefore, it will never come under Article 227. No order was challenged.
No, even for exercising 227,
It is a
there need not be an order.
It is a writ of mandamus. Direct them to
No,
pay.
even that can be 227. There are judgments. Just examine. There, to say whether power exercised by the learned single judge is under 226 or 227, the fact that you had not laid any challenge to any order is no decisive factor at all. It is not a factor at all.
I have to examine whether the learned single pass the order.
27 are substance.
Even a 227 rateable is not maintainable.
Correct.
You can settle law.
We have answered the question also.
Very recent judgment, your
Recent
Lordship.
judgment.
Yes, Mr. Bagh was
Correct.
although he found that some merit was there.
We are helpless because we have no power at all to
That is settled, my lord, since 1986.
just look into that also and come back. But if the society has taken a contention that it had not received any notice, you examine that. That will be very unconscionable. That amounts to virtually misleading the court.
Right.
Just examine this aspect. The section 70, for a moment, just see section 68, 70. 70 speaks of award or order or decree.
Settlement of this.
70.
Reference of dispute to arbitration. Section 70.
Reference of disputes to arbitration.
Arbitration. And arbitration has been done now.
Yes, ma'am.
In your case, dispute to be settled by arbitration. Minus the clause which empowers you to appoint somebody in your own discretion.
It's not an award, my lord, it's a judgment.
Whatever you call it, it's an award.
It's an award.
Arbitration it is.
No, there the nomenclature is judgment.
It makes no sense because whether I call it 6 as half a dozen or only 6 makes no difference because it's an arbitration. In your state, many of the legislations are ill-drafted. Many of the legislation, with due respect to the legislature, I am saying this. They are very, very ill-drafted. They are drafted as if they came from the 10th standard people and that way they have done.
Well, in order portion, it has been reflected as award. Hence, it is awarded that the Orissa State Court.
It has to be awarded. Arbitration is generally whatever you may call it. Judgment is defined under CPC as the reasoning part of the order or decree.
Yes.
Where that word judgment occurs?
In that, which we have.
Oh, that the joint commissioner. That joint commissioner is not from London Law School. He is from Katak School, from Bhubaneswar. Therefore, that contention may not arise at all.
This arbitration clause.
Arbitration.
Arbitration clause.
They will have option.
My lord,
No,
that
it is
petition,
because they will have an option to choose their arbitrator.
No, it's not a question of choosing our arbitrator. Then also, when this agreement was entered into, then this 12.5 came, my lord.
Correct. But now that contention will not lie because now there is arbitration only.
We can't espouse that clause also. That is not, we cannot rely on that. Even if wherever it is there, that managing director will appoint, director of personnel will, those things goes.
That will go.
9/11 will come.
11.6.
No, that also will not be available to you because it only says arbitration.
yes.
And now the arbitration is done.
My lord is saying possibly that this arbitration, whatever they say, and the arbitration
They are one and the same, substantially.
I cannot agree with your lordship straight away. I'll come back on that because I had a discussion with someone who says two are separate things. Anyway, that is something for some other time.
My lord, they have raised that
Your lordship
issue
keep
as
that
a
in mind.
preliminary issue to be decided. That issue goes against them, against which they have not challenged that.
No, they need not challenge. Read, amendment has happened to CPC, Order 43, Rule 1, capital A. It says, any order passed during the pendency of the main matter, can be made a ground for
Appeal. Appeal, that is a 105 CPC.
No, not that. 43, 1 capital A is added by the amendment.
Section 105. You can raise that.
There is also there.
Yes.
Any non-appealable order. That's right. But question is, this is considered by the apex court. They have extended it to arbitration matters also.
I'm not disputing.
105 speaks of non-appealable orders.
Yes.
They can take ground in the appeal.
When
not in a writ petition.
Correct. No, but that makes no sense. They say challenge can be deferred till an adverse order is made.
Yes.
That way.
Only appeal, not in the writ petition.
No, there is writ petition also. Yes, they have said that also. Because of that amendment. Just look into all these things. We have made some profitable discussion so that we have fixed the parameters. Now we have understood. Now only you have to furnish your views and on facts also, keeping in view what Mr. Panda said, how
the writ appeal is.
Writ appeal is maintainable. That also. There is one judgment of Karnataka High Court where intra-court appeal was held to be maintainable, almost in similar line. And author was myself. That has been affirmed by the apex. Just look into that judgment. That is from the Dharwad bench. Intra-court appeal, intra-court writ appeal, even when it is 227.
Here your lordship has taken a different view.
I took a view. No. Because there was no much.
Intelligent people do that.
Not like to revisit it.
No, my lord, intelligent people can change their stand anytime. When my lords hear a better argument.
Your client has done that in this matter.
If your lordship is a better.
Your lordship, I have filed an interim application. Your lordship will pay the further proceeding of the appeal.
I have already filed the appeal.
We are in the part, we have heard it in part now. We are next date we are hearing and disposing of the matter. It will be over.
My lord, the appellate authority will proceed with the appeal.
Don't precipitate the matter till next date of hearing. Let him not, don't take up. We are in the middle of the hearing now.
Yes.
To my knowledge, the appeal has not yet been admitted. It is filed with defect. The defect has not yet been removed.
So that is what my strange. This is off the record, my lord. It was so well managed, we could not get a certified copy from the Joint Register Office till over 3 years.
We don't know.
Anyway, now also that is not available.
Without order, you could have filed the appeal.
Appeal has been filed.
For the
appeal has been filed with an exemption petition, with a Xerox copy. That is filed.
Then what? Yes.
My lord, may call it on 27th, last week of April.
27th of April?
April, your lordship. Or 29th or 30th?
29th to 20.
29th.
All right, 29th, all right. Heard in part. adjourned for further hearing. Yes, Mr. Panda.
Yes. I have a submission, my lord. In the weekly list, serial number 1. My lord, my problem is that, my lord, from tomorrow onwards, my lord, for 6 days I will not be there. May I
You
pray,
will not be there. Then I also will not be there.
My lord, I pray, my lord, this matter will be taken up in the week commencing from 30th of March.
You're also in the supplement list because I have waited.
30th of March.
30th of March.
I have this
30th of March, all right. On
30th of March.
In the supplementary list.
Weekly list.
This side.
I have a small
In the supplementary list.
item number 106. That is a covered matter.
106.
106.
Who is your opponent?
State.
Mr. Panda, just looking. Your Lordship, that will call in the 6th of April. If it is covered.
May I pay your on this matter tomorrow and it can be disposed.
Tomorrow I am not there. Therefore, all right, tomorrow before some other bench.
No.
Item. Your Lordship, only one because item 1, Mr. Patnaik mentioned, that is also a covered matter of the Honorable Supreme Court. Let the matter come in the supplementary list, Your Lordship.
Number 1.
Item 1 of the meeting.
Patnaik.
My lord. That is a covered matter.
I dispute, my lord, but I have no objection, my lord. Rather, I will be happy, my lord, if it will be taken up in the supplementary list. No, on 30th.
But we'll after that we'll take a look.
Kindly. 6 also. It will come in the supplement. I will apply with that.
In our case, my lord, the order has not yet been completed.
Sir, completed. Call this matter in 27th of 29th of
29th of April.
April.
Item 1.
29th of April.
Item 1 date may be given.
Item 1.
Supplementary list, Your Lordship.
It will come in. No, it will come in the same list. Supplementary list or which list you want, Mr.
As your lordship pleases, my lord, I don't have any. Only my problem is that the next week and from tomorrow, because I will not be available, that is.
Taking it after you say 30th, no? 30th.
Yes.
30th of March we have said.
Yes.
Yeah, 30th. Yes. Call.